Well, good afternoon. Good evening to everybody. Mr. Q, welcome to this special edition of Can They Do That? This is Larry Neely. Good evening, good afternoon, as the case may be. And we're beginning our second episode of Can They Do That? We really appreciate everyone joining us, and we'll be discussing police sting operations tonight. And I wish to thank our special guest, King Alexander. And later on, we're going to have Katherine Strohl joining us in the second hour. Mr. Alexander has been with us before, and he's a supervising attorney in Louisiana in the Calcasieu Parish Public Defender's Office in the Great Bayou State. And he'll be our primary guest for the first hour of the program. Ms. Strohl is an attorney who's been with us before, practices in Illinois, and has been with us on, I forgot how many calls, but she just had a decision overturned by the Illinois Supreme Court in the case of People versus Pepitone. We're going to be talking about that in the second hour. And we could possibly have a third hour, depending on how many people are on here and have questions to be answered. So we also want to thank Andy for his technical expertise in getting this program lined up. So thank you, Andy, for all you have done and do for us. So, Mr. Alexander, welcome.
Great to be here, Larry.
I've seen you in the flesh a number of times at our national conference in Atlanta, and we exhibited together. And I believe that was over at the NACTL in the great gambling city, wasn't it?
Right, Planet Hollywood, Las Vegas, Nevada. Yeah.
So we must have engaged with 100 or more people over there, I would say. So and we've established some relationships as a result of that. So tonight we're going to be talking about police things, and we kind of titled the program after To Catch a Predator, which everybody has seen, almost everybody has seen at one point or another. And it's a fairly hot topic around because people don't understand how law enforcement, get away with it. So there's a lot of folks that have been convicted in these stings. As far as I know, practically every state has run or do run these operations regularly. So let's take it back a little bit to the beginning of this. In the last 15 years, states have enacted legislation to make it unlawful for adults to solicit sex electronically. So my question is, were these statutes really actually necessary? Wasn't it already unlawful to solicit sex from people who were too young to give consent to have sex? Did we really need to have these snazzy statutes aimed particularly at doing it online, or was it something that we could have prosecuted with the existing statutory schemes that we had?
That's what we lawyers call a compound question, but sorting it out. Yes, they have enacted these over the past 15 years. Were they really necessary? In my opinion, no, they were not. Was it not already unlawful to solicit sex from individuals too young? Yes, it was already. And I have, from one of the cases I was in, lined out a long laundry list of existing statutes in Louisiana that would have covered this situation or not. And you had a couple of other questions, but I don't know if I've answered all of them. Go ahead.
So, well, that's what I was getting at. Frequently, we have interest groups come in, and I'm on the legislative end. I work in the legislature a lot. We have interest groups come in and say we need to pass a law, and we'll point out, well, actually, this can already be prosecuted. What you're complaining about can already be prosecuted, but they want to feel good by having this particular law. Now, this particular law, to do it online, the reason why they needed this law, but they weren't intellectually honest, the reason why they needed the law was under the existing structure, you could not pose to be a minor. You had to actually solicit a minor under the previous version, so that they could have used. So this, although they couldn't say it, these online statutes, didn't that create the ability for people to pose as a minor? If you were a minor and you were at a video game hall or what arcade or whatever they used to call them, and you propositioned that person, you had to actually be propositioned a minor. The cops didn't dress up and look like minors and hang out at the video arcades, did they?
They have used, and that's how they do stings, actual real-world stings, to catch Johns in prostitution in areas where they have an issue with it. And they have had underage-looking, very petite officers do that and represent themselves to be underage so they could get some leverage and book somebody in for a more egregious charge and then maybe plead it down. But yeah, it made it easier because it made it so instead of having to be out on the street and having someone who looks the part, they have what I call officer pretending. And you've got a middle-aged male who's pretending to be an underage female, generally. And they just do it from the comfort of an air-conditioned office in a comfortable chair.
So, well, NARSOL gets inquiries, and I would say we've gotten inquiries from maybe as many as half of the states about these type of operations, similar to catch a predator. How prevalent are they in your part of the country? Are they widely done in Louisiana?
They were when it first started out, and law enforcement and legislation goes through fads, just as other walks of life go through fads and entertainment and so on. And this was the big fad when we first started seeing it around 2006, 2007. The first case I did has a 2009 docket number, but I think the date of offense was probably in 2008. And I couldn't get the first one that I had. And it's interesting, I personally have not had any that involved a real minor or juvenile. And in Louisiana, it should only have been illegal if it was actually a juvenile, which we define here as under 17, whereas a minor is under 18. And so you've got this year gap. I've only had officer pretending cases. I did know a lady here who was active in a support group called Louisiana Voices, whose son in the neighboring parish, we have parishes instead of counties, who had a 15-year-old that he interacted with in this way and got a terrible deal up there. They eventually moved to Texas. But the ones I had were just officer pretending. And the fad waned later. The second one that I had that was very similar, neither one of these men had an actual minor involved. And both of them totally resisted every effort of the officer pretending to get him to come for a meeting, lure them into our district or state. The other fellow, the second one, was from a Midwestern state, several states away. And they tried to lure him in, and he resisted. But the second one got a better deal. We went to trial on the first one because I couldn't get an offer to something that didn't require registration. The second one I did from the same prosecutor, and the prosecutor told me the reason was that now the law enforcement thinks that they used to think that these who did the computer-aided solicitation were the bad guys. And they changed their mind that they're not the really dangerous guys. The really dangerous guys now, they think their fad now is that the really dangerous guys are the ones who download child pornography. So we don't see nearly as many of them. We get one every now and then, and it's more likely to be a real person than an officer pretending because they're directing their energies to other things.
Well, I know that in my work in criminal defense, I've seen one case where there was actually a minor solicited, and they prosecuted it under the child solicitation by electronic communication device. So it's exceedingly rare. So I'm wondering if this was a creation of a crime that was a solution in search of a problem.
To a large extent, I think it is.
Yeah, so I just my experience is that teenagers really don't go out there looking to have sex with middle-aged and older people.
No.
Assuming that they're assuming
not unless there's a lot of money involved or some good drugs.
Oh, now our adolescents would not be in search of drugs. So, well, why do they devote so much resources to this if it's not a real problem? Why are they spending? You see these large operations, they're multi-agency, and they have a huge amounts of manpower involved, and they do these takedowns like they're taking down I feel sorry for some of these older men. I mean, they're being thrown to the ground and surrounded at gunpoint. Why do they spend so much money on this if it's not a real problem?
When I find myself asking, where is this coming from? Why is there all this big effort being put into this particular thing that we didn't used to see before? Or why have they created this specialty prosecutor to handle a certain type of case that doesn't seem to be any need for? When I find myself asking that why, I find that frequently the answer is grant money, or some kind of federal money that they're told if you establish this type of a program, then you can get this matching or this is free money. And that's frequently where it comes from. And it comes from fads, and it comes from, whoever spoke at the last, National Association of District Attorneys meeting.
So does it have anything to do with the public opinion of people? I take the opportunity to remind people to look at a high school yearbook now and look at one from 30 years ago and look at the fat kids now versus the fat kids from a couple, 3 decades ago. Does it have anything to do with parents being they buy into this notion that their kids are in such danger, and that they really appreciate that the cops are spending all these gobs of dollars to protect them against an imaginary problem that's really doesn't exist? I mean, we've got children who now are so afraid that I can't remember the last time I saw a teenager riding a bicycle in my city. I mean, I see adult men riding bicycles, but the last time I saw a kid riding a bicycle, I can't remember how long it's been.
Yeah, they stay in their gated communities to do that now, I think. But yes, it's. I think that when you see something like this come out, there is a fad aspect of it, but sometimes there's something egregious that happens in the real world, and it makes the media, and the story gets legs, and it kind of sweeps the public consciousness, and people get up in arms about something that is maybe not a real danger. I mean, anything that you think is dangerous, the fallback comparison is always, motor vehicle deaths in terms of the danger from that. And it's just always far higher than any other danger you could possibly encounter. When an airliner crashes, it's horrible, it makes big news, but it's, statistically the safer thing to do. There have been some egregious cases, and not to belittle those, it just, I don't think, ever was the bigger deal, but it was something that you didn't have before. You didn't have young people on the internet forming relationships with strangers who are far away, and then, getting a bus ticket and running away. That has happened. And there was this huge response to it. But was it overkill? Yes. I think that these statutes quite frequently, as I think have a worse penalty than and sometimes they penalize. The original version of the Louisiana statute was it penalized things that would be perfectly legal to do in the real world, because of it made it applicable to anyone under 18, whereas in Louisiana the age of consent is 17. And they just saw the computer as this powerful tool that made it extra dangerous, and so they really wanted to use a sledgehammer for a gnat.
We have those inconsistencies in our statute. The electronic child solicitation by electronic communication device, depending on factors, can be a more serious crime in my state than actually having criminal sexual contact. That would be consensual contact with the minor who's not within the age zone of being able to, being greater than 4 years difference.
That's correct, and that's the same thing here. Carnal knowledge of a juvenile. The felony, there was a misdemeanor version with a Romeo and Juliet mitigation that's a misdemeanor carnal knowledge that, the fellow who hired me to originally, he's now a judge, but to do indigent defense, lobbied for that and got it. But for a long time they didn't have it. They only had felony carnal knowledge. It carries 0 to 10. It's a Tier 1 15-year registration in Louisiana. And it's entirely probationable, not that they always do that. But computer-aided solicitation is a hard labor felony. It's not with or without hard labor. You can't get parish jail time for it. And it's 2 to 10, and at least 2 mandatory without benefit. And then when they amended it after I made my constitutional challenge to it, they fixed what was wrong with it and aligned it to our law, changed the 18 to 17 and some other things to make it, to avoid all the absurdities that I pointed out and the unconstitutionality. And while they were at it, they created an enhancement for a second offense, and the second offense is 5 to 20, at least 5 without benefit. So it's much more serious penalty than the actual act.
So that's something that the listening audience, probably our listening audience, a lot of them might know that, but the public at large doesn't know that. We have the same thing with taking pictures. Now an adult of any age can have sex in my state with anyone over 16 unless there's an authority relationship. But you cannot have a picture of that person of their private parts, because that's a felony and that'll put you on the registry. So you can do anything that you can conceive with their consent as long as they're over 16, but you cannot have a photograph of anything that you've touched.
Yeah, and that's really counterintuitive for young people today. And young people who are of age are responsible for that law, but they automatically whip out their phones and take pictures of everything. I have a client recently who was charged with aggravated rape, and it was a false allegation. He and 2 other Hispanic Americans were charged together. We eventually got that dismissed because when the accuser was in the shower with the other 2 guys, he whipped out his phone and videoed a little bit of it, and the things that she said and her expression and so on made it very clear that there wasn't any kind of an assault going on. And the idiotic prosecutor had the thing, who should have immediately not gone to grand jury. He goes to grand jury, and my client, who was the least culpable, not only had the charge that carries mandatory life without parole, they added a video voyeurism charge, so he had 2 counts. And the other guys, who in my eyes were more culpable, if anybody was culpable, only had the 1. But the video is what saved all 3 of them, and the whole thing was dismissed when the DA took that prosecutor off the case for being the idiot that he was and put somebody reasonable on it. And as soon as our next motion hearing was coming up, she called me and said, "We're dismissing all the cases."
Well, that's good. That's good, King. We got as I move toward the end of my questions, we've got a couple more to go. But entrapment, everyone wants to know about entrapment. What is entrapment? Can you explain in layman's terms? Everybody on this call has heard the term, but what does it mean for entrapment? What are the elements for someone to have a viable offense, defense of entrapment?
The layperson looks at this situation where you've got officer pretending out there, dangling the bait and tempting people, and think of that. Well, isn't that entrapment? Well, it could be if the officer crossed a certain line. The entrapment defense is hard to make. It has to be a really clear-cut case. If the basic thing is that if the target of the investigation had a predisposition to commit the offense or initiated it, then that's not considered entrapment just because the police put a temptation out there. It is very much like dangling the bait. You think about the John DeLorean case, was actually a cocaine conspiracy, but that had elements of both entrapment but also of conspiracy and an attempt to withdraw from the conspiracy. And the confidential informant in that thing for the FBI, when DeLorean tried to back out, he said, "Oh no, you're dealing with people here that they don't look kindly on trying to, but once you're in, you're in," and that gave him the defense he needed. This is different from that, but the officers try not to be the ones to initiate the sexual talk. They'll try to encourage it. And I'm trying not to give you a long answer here, but I can tell you, and I chat online, and I did at the time, and I believe they came after me at one point, and it was after I had tried the first of the cases. Not going to use names, but the first one that we had to try was, I'll call Client A, and the one that I settled as an obscenity, which most obscenity in Louisiana is not a registration offense, but he was lured into the state from this Midwestern state. And when he tried to go home with what was a non-registration offense here, then he had lost his home, that he was his home because he was incarcerated before he made bond. And proposed to move in with his father, and his father's house was too close to school, and he couldn't do it. So it was a registration offense in that state. So he ends up back in Louisiana, where he never lived in the first place. So I mean, it shows how stupid policy this is. They're saying these people are dangerous, and yet they're enticing them to come here. And then because of the difference between the state laws, he ends up having to come back here to find work and a home, and ends up staying here. It just seems like stupid policy. What if they lure somebody in, and instead of going to the assignation with officer pretending, they see a playground full of children and decide, well, I'll take a bird in the hand, and that other one might be a cop, which it was. And, it's just stupid policy.
Well, let's drill just a little deeper in the entrapment. So in terms of the prostitution, John, so if the cops put the hottest girl and guy that they can find out on the street, and you're out cruising, that would indicate a predisposition if you're pulling up and talking to them. So the fact that they say, I'm not a cop, and because that's what you see on the TV, are you a cop? And of course they always say that they're not.
That's a total
okay.
Myth,
That's okay for them to lie because you were predisposed, you were looking for sex. But say that the person calls you up and says, King, I've got this great plan. I know the delivery the schedule of the Brinks truck. And I know the layout of the bank, and I know how that we can take this thing down. And then when you say I'm in, and then they flash the badge and say I'm a cop, they provided you the encouragement, and you weren't necessarily predisposed. Do I have that right? Is that kind of a simple distinction between where there's a predisposition and where there wasn't?
Oh, what, the unlocked or the money falling out of the back of the Brinks truck?
If the cop calls you up and he turns out to be a cop and says, "I've got this great plan. I know when the truck comes. I know how to get at it."
Oh yeah, they're actually soliciting. Yeah, it's their idea. The whole thing is their idea in the first place.
That's a clear case of entrapment.
Right.
But when you're online, like in the case of your client B, the oil platform worker, he was in an adult chat room, had no intention of being approached by a minor, except that the cop pretended to be a minor. Isn't that getting very close, because he's in a room where people have certified that they're of age, and then the person pretending cop says, "Well, I'm here, but I'm actually only XYZ age." I forget what age that cop pretended to be. Isn't that in the gray area, King?
I think it is, and we made that argument because, and the client pointed out to me, is that this was in a chat room that was supposed to be 18 and over. And so I cross-examined it was a state trooper in that case, and I cross-examined officer pretending that, isn't it a fact that this was an 18 and older chat room? And therefore, how did you even get in there claiming to be underage? And he admitted that, well, there's a place, it was a Yahoo chat room. And to be in the chat room, you were supposed to put your age. But they found a loophole in that if they didn't give an age at all, they were able to get in. If they put an age that was under 18, they could not get in. So they just didn't put any age in. And once they were in there, then they could represent themselves to be whatever they wanted.
It was more egregious than that in that case. So I don't spend a lot of time on it, but it was more egregious than that, because the person, the client B, was not interested in a minor, and in fact the cop said, "I've got an older sibling." And that's who he expressed interest in, and then the pretending cop said, "So you don't like me now?"
Yeah, and there was a lot like that, and they said, well, it's Yahoo says it's for 18 and older, but they made it possible to go in there without giving an age, and we know for a fact that people who are underage are in there, and there are hookups going on between people who are older and younger. And the client in that case, you may have noticed, I sent you the scroll, I think that.
Yeah, I was reading the scroll. Yeah.
Yeah, and they're talking back and forth about the age difference, and he said something in his misspellings and everything. Well, it's It's not how old you are, it's how you feel about the person. I think he spelled feel, F-E-L-L, fell. But that kind of thing was kind of incriminating. It was enough to make the jury queasy about him, and the fact that he was a little bit below average intelligence and worked as a utility worker on an offshore platform, but they represented him as being bent. And I think they made the jury, at least 10 of them, this non-unanimous verdict state, where they can convict on a hard labor felony with only 10 out of 12. We might get that changed this year. We got it through the Senate by 2/3 vote last week. I was heavily involved in that. But yeah, that's what you had. And they cut a lot of other corners, because the trooper printed out the scroll from his own computer instead of using an investigative subpoena and getting it directly from Yahoo. And I objected to that. And the judge, he just let it in, and there were a whole bunch of issues for appeal. And unfortunately, the appellate project attorney who ended up with it just waived all of my meticulously preserved issues, constitutional and statutory and otherwise, and only appealed the length of the sentence, which we didn't even care about. So I was highly upset about that, and kept my appeals to myself for a short time afterward, but I couldn't keep that up.
So, well, when we get to juries, this is going to be my last question as we move towards the callers, but the entrapment isn't that something that the jury decides whether the person's been entrapped or not? Have you ever found
it is a fact issue? Yes.
Yes. So the jury determines the fact whether entrapment occurred. So have you, in your experience, how often do you find a sympathetic jury when there's a minor victim involved? It's rare. I mean, I think I've been on a team where we've got an acquittal or two, but isn't it very difficult to find a sympathetic jury when it comes to?
Right, and you have just hit on the touchstone of these cases. I think that the reason why I won 2 of the 12 jurors that did not want to convict, but got outvoted, they could be disregarded in the state, is because it was an officer pretending case, and this was new to them, and they thought it was odd and everything, but they heard arguments about how this is a problem, and we've created this program to address this problem, because it's better that they try to hook up with me, officer pretending, than with your kid. But if it had been a real juvenile, a real 13, 14, 15-year-old, then that inflames them. They're more skeptical when it's this kind of a thing. It is devious and so on. Of course, with it having been publicized on television with this To Catch a Predator thing, then they feel a little bit like they're participating in something that's been on television, and that's exciting. And the more of them are agreeable to go along with it.
So, well, I'm going to wrap up my questions, and I'm going to switch to the give people a chance.
Q&A session has started. To ask your question, please press *6.
So anyone who wants to ask a question can press *6, and we'll start filling the queue. In the meantime, our delightful producer has an announcement to make So, Mr. Producer, what would you like to tell everyone?
Thank you, Larry. Appreciate you doing the program, and thank you, King. And Catherine is here in the wings. Guess we could call that the green room. But I wanted to announce that these programs that we do for NARSOL will be available for download as a podcast, where you could use iTunes or Google Play Podcasts, etc., or your favorite podcast app on your phone. And, maybe you work second or third shift, or you're just not available to get to these phone calls. And so you'll be able to download them, search for Can They Do That, or search for NARSOL in action, and you'll be able to subscribe to them in your podcast app.
Is that it?
I think so, unless you want to ask any questions about it.
Thank you, Andy. Is there anything that would be complicated for a person that's at my level of technology to understand about what you just said? If they're not a podcaster, they're not going to understand it, right?
I think that's probably true, but it allows you to download it and listen to it while you're driving to and from work at 2:00 tomorrow afternoon or something like that. It makes it significantly more convenient to consume this content if you're not able to join the call when it happens.
So thank you, Andy. Unfortunately, I did not press the recording button, but our producer is running his own recording, so we still do have a recording of the show, right, Andy?
That is correct.
Okay. So before we start taking questions, I'm going to read this disclaimer that has become a part of the show. Keep in mind that responses provided on the program are merely intended to offer guidance and should not be construed as legal advice. We cannot cover the specifics of any individual situation sufficiently to know what the most prudent course of action is. So NARSOL advises all participants to consult with an attorney in their jurisdiction to determine whether or not there may be a viable cause of action. So if Mr. Alexander or any of our guests tells you that something is not kosher and that you probably have a cause of action, don't say to your PO or whatever, well, I talked to an attorney on NARSOL and they told me this, because this may be very different. There may be specifics that you need to find out. So this is just general. This is like Handle on the Law, if you've ever heard that program.
Yes.
So now, do they run that in Louisiana, King?
Oh yeah, we get it locally on AM. I enjoy it. It's mostly California oriented, but I enjoy it. The guy's funny.
Yeah, well, that's the marginal legal advice we're giving.
That's what he calls it.
So we're going to go to our first question, and before we take questions, please stay on this topic and keep it to a question. And if it sounds like you're giving a speech, I'm probably going to suppress your microphone and come back to you and give you a chance to compose your question. After you ask your question, I frequently put the person on mute to try to keep down background noises. We're not cutting you off, and we will unmute you, and we will allow you if there's a follow-up needed. But we turn each person off because we get too many background noises from backhoes and screaming kids. So anyway, we're not trying to be rude. We're just trying to keep the program where everyone can hear us. So first caller, you're on NARSOL in Action, area code 646, I believe it is. Go ahead.
Yes, hi. My name is Mona, and I'm so glad to listen to this. My brother is currently serving a 10-year sentence on a case like this. So we had a very unpleasant crash course in the entrapment defense and how difficult it is to prove. And my question is really to ask for, I guess, your opinions on I understand the legality of the predisposition or the pretending officer not making the first move, and therefore you can't use the entrapment defense. But is there any kind of pushback from professional societies like this or others as to really the ethics of the pretending officers, not just dangling a carrot, but in a way creating an atmosphere that encourages criminal behavior that may not have manifested without that encouragement? So that's my question, and I appreciate your feedback. Thank you.
That is a great question. I really like that. Thank you.
Yes, Mona, and I sympathize with your family's situation. That is terrible. There are very few mainstream voices that have any sympathy at all with our cause. The main one that I see is Reason magazine, which is libertarian in its outlook. They did an article on what Katherine Strohl will be speaking about, and a very good one. They consistently chime in on this, and then people who write law review articles, law students and professors and so on, write about this, but very little other. You're getting a few columnists, maybe a few local, maybe a few syndicated, who have more sympathy for this, but it is the most unpopular of all causes. As far as the entrapment, I can tell you what happened to me is that I'm in an AOL chat, and this person, there's young people and there are old people, but most people are 50 or older. And this person initiates, and they're initiating, a private messaging conversation with me on the side, and Marie Kell 14, and the 14, and this is a typical thing that they do, is put a suggestive young age as part of the screen name because it kind of enhances their evidence, and that I do music and so on, the back and forth, and says, would you like to see a picture of me? Sure, just not anything inappropriate. And it's a clothed person, but underage, petite, clearly. And then the cop, this is when I began to suspect it was a cop. And I wasn't interested in anything like this. But she says, so you see by picture, you will become very erect. And I just didn't respond to that at all. My God, I mean, what kind of real 14-year-old talks like that in the first place? They don't. So it made me think that they might be really trying to come after me. And that comes maybe it's like if you don't say anything, you don't respond to it, then they go away. But the line between being enticed and a person's biology taking over, because unless someone is prepubescent, they are biologically mature, and nature does work on people. So I don't condemn the people who succumb to this. But it is very suggestive of entrapment to me. But you have to convince the jury that it really crossed a line. And I made that effort in the one case that I tried, because it's like the cop breaking into an adult room and doing various other things that I thought were not kosher. But enough of that Louisiana jury disagreed with me. I don't know how well I've addressed your question, Mona, but I hope I've given you some insight.
Am I still on?
Yes, you're on,
Am I still on the phone?
Yes.
Oh, okay. Yeah, I mean, you addressed the question, and, I think the short answer is, like you said, there's not a lot of voices out there taking the side of people who are being, who may have, desires to see someone, or, they're in the room in the first place, so therefore there's the whole predisposition thing. But yeah, I mean, I guess part of our concern and frustration is the sense that, in the effort to protect people, it seems as if law enforcement agencies or pretending officers are, it is a gray area or a fine line between protecting people versus creating criminals where maybe there wasn't one to begin with. So
I see it as victimizing.
I appreciate the Reason magazine. I beg your pardon.
Well, I see it as victimizing because they're creating offenses where no offense necessarily ever would have occurred.
So that was a great
and ruining lives.
Question. Yeah. Great question, Mona. Thank you.
Yeah. Thank you.
So, area code 217, you're on. Can they do that? I'm so used to saying NARSOL in action.
Hello there. Can we hear me?
You're great. Go ahead.
Hello?
Go ahead. You're on the air.
Okay. You're a lawyer guy. I had the exact same, since he mentioned AOL, that's what happened to me in 2008. I happened to be a well-known, or was, a sports official, high school, college kids. And somebody decided, they knew who I was. I was in a room called We Love Older Men, okay? And I was living with someone, so I had no interest. Anyway, that person initiated the contact, like you said, and they sent me a picture of a cheerleader. So that's what made me sort of think this person knew who I was. Now, unfortunately, I wasn't smart enough to stop it at that point, and I continued the conversation for a couple of months, actually, unfortunately. Then I decided, or they decided, they wanted to meet. Well, I made the mistake of going, to make a long story short, to meet. My point was, the person on the other end was very suggestive over the months. When I finally got to a park, they not only arrested me, they had me on my knees with a gun behind my head, telling me that I was gonna, they'll use it if I was to move. Hello, are we still there?
Yeah, we're waiting for a question. So are you headed somewhere?
Been there.
Not
exactly, but I've had a cop tell me that a gun was aimed at the back of my head. And after I talked to the cop for a while, I couldn't see him. I said, "Is the gun still aimed at the back of my head?" But anyway, you get to the question, please. My
question is since they knew, would that be entrapment? Since they knew who I was a fairly well-known sports official, and when I was arrested, the guy on the other side of me had all these emails, and I looked at him and I said, "Were you Ashley89," which was the name he used? And he said, "I can't tell you." And I said, "Well, you just did, didn't you?" I guess my point is, was I earmarked because of being known in the area, or was I just another one of the random victims, you might say?
I would be guessing, but that sounds like it was probably not random. And when you think about the Jerry Sandusky case, and I saw a supposed female expert on the pedophile. Of course, they overuse the word, they misuse the word pedophile. That's another pet peeve. I won't go into it right now, but there was someone on the Lisa Gibbons show, and saying that the predator puts themselves in situations of having a lot of young people around all the time, either children or adolescent, and basically this was in the wake of the Jerry Sandusky case, and there he was, the sports figure who had a great number of young people and the ability to recruit them, and you see it with the priests and the youth ministers and so on and so on, those type of people. So they might have targeted you because you were involved in youth sports and wondered whether you had predilections, and you probably did not, but they were able to actually create a kind of an emotional attachment by this medium. And if you've ever seen the show Catfish, either the film or the series version of it, people can come to believe that the other person on the other end of the computer is something ugly other than what they are, and they invest real feelings in it. And these police are exploiting that. And as Larry pointed out, in the case of my client A, that when she mentions she, who was really a male, mentions a sister who is older, then he expresses interest in the older sister, and then the cop starts acting like hurt feelings, and he doesn't want to hurt the feelings, Not
that I'd never ever been arrested for anything other than traffic tickets, and the reason I actually answered the Ashley 89, this was in 2008, so I thought 89 was the birth date. That person would be at least 18, maybe 19. That's one of the reasons I started she started the conversation, or he. And so to me, that was total entrapment, but.
Yeah, and that is an aspect of it. And of course, they'll deny that had anything to do with it. They may deny the numerical intention. But once you're emotionally invested and they kind of slowly break to you, well, I'm actually this old. But every one of these statutes is written that lack of knowledge of the victim's age shall not be a defense. And when they write it to make it legal for them to do these officer pretending stings, that's not a defense either. They have to convince the jury that you reasonably believe that they were the age that they eventually represented, and that's enough. And I'm very sorry that you were. To me, it's entrapment, but legally, it's not probably.
Yeah. So we're gonna move on. Thank you for the question. We've got a lot of people in the queue, so we're gonna. Area code 419. You're on for what is it? A program. Where can they do that? Go ahead.
Hello. I'm calling in regards to when the sting operations involve websites and where the sting operation is posting child pornography in files. And it was posted on a site that was a peer-to-peer site. So where people shared a lot of things, where you could go and download, regular everyday movies and stuff. And there was a large police agency that posted a set of child pornography files on there. Wouldn't that be considered pandering on their part because they're distributing it?
That is one of the great paradoxes of this, and because they're actually putting it out there. I don't know if they're putting it out there or they're just aware that it's out there and they're monitoring it in such a way as to know who clicked on it and downloaded it. And I have a question for you. Are you familiar? If you know, were the titles of the files such that they were very, say, 9-year-old being raped or something like that? Because I've seen that. But the videos themselves sometimes are very, very grainy, and you couldn't tell whether it was a pygmy or a midget or whatever, or even a real person at all. I'll let you answer.
Yeah, I have no knowledge of what those videos actually were. I know that there was a set of, I think, 10 of them, and there were like 2 or 3 that were viewed, immediately closed, immediately deleted. You know, it was just an intense curiosity as to what the heck this stuff is. But the person knew that it was, you know, pornography. However, you know, there was no, you know, intent to, you know, for any gratification. There was no history of it before. Actually, you know, with the whole case, then they did forensics on all the devices that this person had. You know, their laptop, their cell phones, lots of cell phones. They found absolutely nothing. So they decided that, well, they would just give, you know, probation, but still labeled it as a tier 2.
Yeah, it's tier 2 in Louisiana.
On this person's part. Yeah. So it just seems odd that they can tell this person who had no intention of really sharing it. Unfortunately, it was on a site that is a shared site, but there was evidence that it was never opened by anyone else. It was only opened by this individual and then closed and deleted right away. But
then the police were totally behind it. And they use file names that are very, very suggestive of the crime, because that kind of strengthens the evidence of the intent was to look at something that was clearly illegal. But they are exploiting human curiosity, and it isn't necessarily for sexual gratification. But so they started writing statutes that didn't necessarily require it to be for sexual gratification, because some people the gratification or the motivation might be curiosity, but for others it might be to acquire the file and to somehow monetize it. I think it's very unfair, and the penalties are so severe, and the scarlet letter of registration is so severe. They are ruining lives, and it is so stupid. I'll be glad when our society evolves beyond this nonsense. The pendulum can't swing one way forever. But yes, that's what I see being done, and they are very severe. And obviously, entrapment defense is the first thing that most people think of. But anything that tends to suppress them getting convictions. We have elected judges in this state. They're politicians, and the last person who's ever going to get a break is someone who is charged with the sex offense against a minor or juvenile.
So, well, King and the callers, we're going to have to accelerate questions and answers. We're coming towards the top of the hour, so let's get a 541. What is your
lightning
question?
round?
Lightning round.
I'll try to be brief. I'm curious about why their approach isn't geared more toward addictive behavior. There's so much emphasis right now on addiction, whether it's prescription drugs, illicit drugs, obviously alcohol. There's avenues for people to get help. I think it's fair to say that, I mean, with a lot of people, it's curiosity. With a lot of other people, it's addictive behavior.
That's an easy one. It's an easy one.
I don't know why they don't.
That's an easy one.
They don't take the.
It's an easy answer.
Yeah, they don't take. What's that?
It's an easy answer.
Take this one, Larry.
Yeah, it's an easy answer. The citizens are not ready for that. We don't believe we're a punitive nation, and we don't believe that we believe treating that those type of services that cost money and that's mollycoddling criminals, and we're not ready to provide treatment. We're not ready to treat this as a mental health issue. So it's a simple answer.
And law enforcement doesn't want to mollycoddle. They don't want to nursemaid people. They want to take people down. You know, it's just like kissing your sister if they're just going to put you into a program.
I think the caller's in one of our progressive states, and he probably doesn't see that as necessarily his state's outlook. But that's the way we're by and large.
It is that, and chat, and just spending a lot of time on the internet, in chat or anything else, is intermittent reward. Is the what they call it in psychology is when you get a little bit of endorphins from from the back and forth, and it's hard to break it off and return to the real world. They're exploiting that, and it is very sad. I think that we will go more to a healing situation, but it has to get to the point of conservatives will respond to it when they think we're spending too much on doing it, on enforcing it, not because they feel sorry for the people whose lives are ruined by it.
So,
and I consider myself a conservative, but that's unfortunately what the thinking is.
So welcome to the from the Tar Heel State. Go ahead, you're on.
Oh, thank you very much. My name's Sam. I'm from Raleigh, North Carolina, and thank you for being on today. Children and young people seem to be the newest and most increasing registrants to the registry. What I'm seeing here in North Carolina is campus police and other agencies seem to direct entrapment towards students instead of educating students or the schools by targeting such apps as Tinder, Instagram, or other apps that I would say teenagers or the young people will use. Many colleges and potentially high school students borderline its population with age of consent, which vary from state to state, and police seem to be seizing an opportunity to create charges in this rape culture when perhaps none is present. Police can charge consenting parties in North Carolina with various underage actions, even if the parties have no interest in filing a complaint. Many students are presented with lesser charges as a weapon while still being subject to registry requirements. The question is, do you think that's a loose form of entrapment or creating a constructive culture of abstinence? It seems that some officers are violating the spirit of the law to keep the registry numbers up.
Great question.
I don't doubt that they're doing that. It certainly is exploitation, and I think that parents of these young people are going to have to become very angry. But the person that isn't close to someone that anything bad in the criminal justice system has happened to, I hear this again and again, that people telling me when something happens to them or a member of their family, is this whole experience has completely changed the way I look at law enforcement and the criminal justice system. And I say, that's what the experience will do to you. I don't know how we reach all those people who haven't experienced it yet. There needs to be more writing about it and more talking about it, and people need to see that law enforcement is trying to perpetuate itself, and some of them just kind of inherently get off on doing this kind of thing. They've got their own weirdness and issues. That's what I would say to you. I think we have to raise consciousness on it, and it requires courage. And all of you who belong to NARSOL and participate are exhibiting that courage already.
So, King, we're about up on a hard break. We could try to squeeze in one more if the person can do a quick question, and you can do a quick answer. So go for it, area code 202, very quickly. Well, all right, area code 202. Area code 251, try a quick question.
Hi, my name is Jack. I had the exact same situation happen to me for
you got 10 seconds. Make it quick.
Obscene materials. Yeah. So I was interested in the comment you made that law enforcement doesn't seem as interested in this now, and wonder if that extends to being able to find any kind of relief from the registry. In that context, that they're not as interested in prosecuting it now as they were.
Where I am, the interest, I'm not seeing these officer pretending stings being carried on, which is the topic here. Every now and then they get a real world case, but I don't see the stings, and they're putting those energies into other things. The way that this is, did we hard break out?
So you got about 5 seconds, King, but the answer is
okay. Well, there is no relief from Tier 2 registry in my state. There you can get a 15-year Tier 1 reduced to 10 years after 10 successful years. As far as other relief from registries,
we're going to stop it there. So folks,
it hasn't happened here yet.
We're going to be back at a 5-minute break. We'll see you on the flip side with another hour, and this is the NARSOL in Action Broadcasting Network.
Hi, this is Brenda Jones, NARSOL Executive Director. If you're hearing this, you know just how important our work is to citizens across this country who struggle daily with the challenges of being on a public registry. You know what it means to wear that scarlet letter or to have a loved one wearing it. NARSOL is fighting for the rights of millions of registrants, their family members, and their children to live free of excessive repressive laws that keep on punishing long after their sentences are over. We are filing lawsuits challenging restrictions, and our volunteers are fighting in state capitals, not only to prevent new bad laws, but also to introduce positive change. We need you to continue our work. Have you joined us yet? Made a contribution? Go to narsol.org today, that's NARSOL.org, and click on Join or Donate. Do it today before you forget. Become a part of NARSOL's fight for your rights.
Just like people believe that the single greatest threat to their children is stranger danger, when the absolute consensus of facts is that 90% of child sexual abuse cases happen within the family or someone who has access to the child through a priest or a coach or a teacher. Stranger danger is the least likely thing that's going to happen to your kid. Much more dangerous to let your child go to Boy Scouts or Girl Scouts than it is that they're going to be randomly picked up in a playground.
Are you tired of hearing what feels like gloom and doom all the time? Tired of the message that there's no hope? That somehow life is over? Humans on the Registry, that's humans.narsol.org, has been launched with the goal of sharing some positive messages about registered persons. This project of the National Association for Rational Sexual Offense Laws seeks to bring a little light and hope and humanity to this difficult subject through short stories about registrants who are succeeding in spite of the obstacles in their paths. Are you a registered citizen who has a positive story to share? Have you found meaning, a better tomorrow, a loving family, built a new life? Come tell us about it at humans.narsol.org and show the world and other registered citizens that we all have reason to hope.
Well, we know low-risk offenders have very low rates of reoffense, right? And even the highest risk offenders, after 15 years, there's almost no risk of reoffense. So why wouldn't you want to at least let people get off the registry, even without any treatment? We know that after 15 years, people who commit sex offenses desist.
That's ridiculous.
It's not
that
ridiculous.
That is so untrue.
That's not true.
There's
disharmony. Okay, wait, please.
They don't age out.
They
do not age out.
They do. A meta-analysis of 21 studies by Carl Hansen showed across the board there is desistance, even for the highest risk. The lowest risk right away have a 1 to 5% chance of resistance. I'm not assuming. It's a meta-analysis. I didn't do it. It's by Carl Hansen. It was published in 2014.
Welcome back, everybody. We're beginning our second hour of Can They Do That? So we're going to be joined by another guest, Ms. Katherine Strohl. Welcome, Katherine.
Hi, Larry. Can you hear me?
We can hear you great.
Okay.
Thank you for joining us. And this is the best, hopefully this platform works. It's the best audio we've had from your previous calls. So thanks to Andy and you guys working together on the sound. We're looking forward to having you on many calls in the future.
Oh, thank you.
So there were a couple of people in the queue that we if you want to take a stab at, we can go ahead and see what they wanted to ask about. And then I've got an announcement that I'm going to have from Robin. Somebody's making a lot of noise in the background. I've got an announcement I'm going to have Robin make, a little housekeeping matter promoting our conference. So I'm going to bring him on right now, and we're going to get that out of the way before we start, and then we'll get with the second hour. So Robin, welcome to the call. Tell us what you have to say about. We can hear you great.
All right. Well, I want to do a little bit of conference promotion. Many of you may or may not know. In case you don't know, this will be the 10th conference by NARSOL, the National Association for Rational Sexual Offense Laws, and we're very excited. The conference dates are from June 8 through 10, and this year's conference is going to be held just outside the city of Cleveland. In a part of Cleveland appropriately named Independent. The theme for this year's conference is The Road to Independence, Reclaiming Full Liberties. And we're very excited. We have a really exceptional list of featured speakers, which will include Paul Dubling and the award-winning producer of the documentary Untouchables, David Feige. We'll also be joined this year for the first time. We'll actually have a presentation which will include 2 state legislators. They're from Ohio, Senator Michael Skindell and also Senator John Eklund. And they will be presenting a mock committee hearing, which will be facilitated by Connie Nolder, who's a well-known lobbyist in that state. We'll also be joined by Jeff Gamso and attorney Leah Bickerton. So if you've not been to a conference, it's a really wonderful experience. It's an opportunity to feel at home with people who have very many of the same challenges and apprehensions about life, either being on the registry or living life with somebody who is on the registry, which can be just as challenging. So we really are encouraging you to register and to come and to join us. All the conference registration information can be found on the conference website, and that URL is conference.narsol.org. Again, it's conference.narsol.org. That are joining us, this is your formal invitation, and we look forward to seeing you there in Cleveland. Thank you, Larry.
Thank you very much, Robin. So
the recording has started.
We're going to record this hour because we're going to be given some more marginal legal advice. So I reincorporate the disclaimer I read in the first hour that this is not intended to be specific legal advice, that you're encouraged to consult with a practicing attorney in your jurisdiction. We'll do the best we can, but don't take this to the bank with you. So Ms. Strohl, again, welcome. You practice in the great state of Illinois, I do believe.
That's right.
And so there's been some news out of Illinois regarding your work and a case that you've been involved in, People versus Pepitone, and NARSOL was involved in that case. So we got a decision from your state Supreme Court, and what was that decision?
The decision reversed our victory in the appellate court, and the Supreme Court said that the statute that we challenged, which permanently banishes anybody with the label child sex offender or sexual predator from ever stepping foot in any public park, bikeway, trailway, conservation area, or building on public parkland throughout the entire state. They said that statute is constitutional.
And they said that on the basis of the lowest threshold of review, rational basis, which is the basis for the intermediate level court saying that they didn't even pass the rational basis test. So what is the rational basis test? What standard does something have to meet to at least pass a rational basis review?
To pass rational basis review, a statute has to have a reasonable connection to the legitimate government purpose. So the alleged government purpose here is protecting children. So then the question becomes, is banning child sex offenders from park reasonably related to that purpose?
So, well, there is a remaining claim that is yet to be determined. There was no need to determine it because the appellate court said, screw this, we don't even need to look at that claim because it doesn't even pass rational basis. Now that they say it passes rational basis, what is that remaining claim?
The remaining claim was an ex post facto challenge to the statute. So the claim that we won on in the appellate court was a facial challenge, which means if the court found it unconstitutional, facially unconstitutional, then the statute would no longer apply to anybody. The ex post facto challenge is only, if we win on that, it will only be helpful to people who committed their crime prior to the passage of this statute in 2011. So if your crime happened after the statute came onto the books in 2011, you're not going to get the benefit of a win on an ex post facto challenge.
So, well, NARSOL will be with you guys, the team that working on this. We will be extending our help in any way we can. This is something that's very important to us and to so many, that you pay taxes and you can't engage in a basic function like taking your child or your dog to a park. And
or in Illinois, it means you can't go to any one of the 11 museums on Chicago Park District land, which are some of, iconic cultural institutions. You can't run in the marathon, which passes through many parks. You can't get off a Metra train if the station ends in one of the parks, and many do. It's extremely debilitating. It has huge ramifications beyond just not being able to go to what we quintessentially consider parks, places with grass and playgrounds. It's much more than that.
So the remaining claim, so what's the trajectory? So the Supreme Court said, go back and consider this. What court considers this? Would that be the appellate court, or does it go back to the trial court? Where does it go from here?
It goes back to the appellate court. And the good news for us is that we will have the same 3 justices who sat on the panel the first time. And, 2 of them were already favorable to our bigger claim and the more difficult one to succeed on, and tend to be kind of, so, we could file a cert petition right now and appeal the issue that was decided by the Illinois Supreme Court straight up to the United States Supreme Court. That would obviously cause a delay in getting the case back to the 3rd District, and it might just be a delay for them to reject the appeal, which is likely given the odds. Whereas, I've been in discussions with a couple of attorneys that are very familiar with the case, and I think that there might be another viable facial challenge. I need to before saying that I'm going to raise another issue and try to get it struck down for everybody, I want to do my due diligence and do some more research. But if that's the case, then I want it back there as soon as possible. So the time frame for that is the mandate from the Supreme Court remanding the case will issue on May 10th. And once the appellate court gets it back on May 10th, they will set a briefing schedule, which would be, for me, I think my 35 days would start running then.
So, well, we were disappointed, as I'm sure you are. It's always...
it was devastating. I mean, what was problematic with the decision was the way the court justified their decision. They said, we understand that these alarming recidivism rates have started to be discredited and have been challenged. Nonetheless, we're going to rely on them and not pay attention to, the convincing social science that the defendant has brought in. We're going to ignore that, stick with the old state of affairs, and just say the legislator can do whatever they want when to people who are classified as sex offenders. So, terrible decision.
So, well, let's get to the fun part of can they do that, and take some questions from people. Hopefully we can provide some some encouragement for some people. That's not the news we'd like to share, but we kind of added it into the agenda because it was something that happened after we started planning this call, and I didn't want to wait till we set up another call to talk about it. So we've covered the basics. So we'd be delighted to have you come on as the strategy unfolds, and as we get closer into it, we can go into more detail. So so we had some people waiting in the queue, and everybody who wants to ask a question, hit *6, because the queue has emptied out after we went to break, so we can refill you guys and take some questions. So so I think this might be Pennsylvania here. 484, you're on. Can they do that?
Yes, I'm here in Pennsylvania, and we're starting our own advocacy group regarding the reform of sexual offender laws. I guess my question is, as part of the rules of parole here in Pennsylvania, a sex offender has to have a treatment group where he goes on a weekly basis to a treatment group, and they make no distinction between someone who looked at child pornography versus someone who molested their own children. They're all guilty of sexual abuse of a child. And I guess my concern is that these treatment groups are not licensed, the counselors are not licensed, and they're actually psychologically harmful. But these groups rule the sex offender registrants' lives, because if they say you're not compliant, the PO is putting you back in jail. And it just doesn't seem that, and that in Pennsylvania, we're not allowed to go out and get a psychologist and a psychiatrist on our own privately in place of that or in lieu of that. That's mandatory for sex offenders as they leave. And they're aggressive, they're harmful, and it just, I've watched it on a weekly basis with my son, where it just drives them back down. How can we change that?
Great question.
Yeah, Larry, haven't you spoken about this before? Because I don't know that I have a great idea. I understand the dilemma and the problem. I just, I don't know what grounds the lawsuit would be filed. You'd have to file a lawsuit. You have to get a bunch of evidence, demonstrating the negative consequences of these groups and convincing a judge that people should be differentiated based on their crime. I just think it's really unfortunate, and I don't have any sort of solution to offer.
It's tragic because most of the treatment, I know we've got one state, and that's Maryland, where they do everything as pure as the wind-driven snow, and that's a joke, an inside joke. But most of these treatment programs are nothing more than, I call them a collaborative fishing expedition. They're looking for ways to violate the person. There's very little medical value in that. They force a complete release of information. They treat the contact and the non-contact and the offenders the same. Each have different needs in terms of what their offense was. Not to say that one offender is better than the other, but the impulse control person that has a serious impulse control issue has a different problem than a person who had a crime of opportunity, where they happened to have an overnight visit with the niece who had gone through puberty, and they couldn't resist touching one time over the bra. I mean, you've got differences, but the treatment is in my opinion largely bogus, and it's a financial racket. What we do about it is going to be difficult, because the court's going to be reluctant to intervene, because those are the experts that are providing this, and they've come in with their literature saying how that this is wonderful, and it's. I don't know that there is an answer. It's unfortunate, but I don't have an answer either. So sorry. I hope that the Pennsylvania caller. We're trying to identify all these noises, and we're trying to cut them out. So I suppressed you. So I'll just come back and say for a moment. Did that help any before we move to the next call?
Yes, that answered my question. Thank you.
So okay, thank you for the question. So area code 218. Go ahead. You're on the. Can't keep this program straight. Can they do that?
Hi, Larry. So I'm in Minnesota, and I am compelled by parole and treatment to commit to do a polygraph based on sexual history. During that test, I asked to see the pre stuff before the test. I'll be taking mine in a few weeks, and the pre-test questions include things that relate to parole violations. The test itself does not. It just asks, have you been honest with treatment and have you disclosed all prevalent things? But the pre-test is required, and it's turned over to your parole agent upon completion. I believe that this violates Fifth Amendment rights and being compelled to do it anyway, and I'm wondering if there's anything I can do to assert my Fifth Amendment.
Well, I'm going to drill in a little bit on your question. I usually don't do this, but the pretest interview is supposed to be. I know a little bit about polygraphy. You're supposed to be setting the person up for to take the examination to make sure that there's a clear understanding of what's meant by each question. So if they give you pretest questions that have nothing to do with the questions of the polygraph, that seems very odd. But I don't know that you're under any obligation, and the attorney's going to pipe in here in a minute. But if you're going to talk to a polygrapher who's asking you about a lot of stuff that's unrelated, I don't know what your obligation is to answer those questions truthfully. You have to be cooperative, but.
I mean, I think the point is, though, the test will catch him lying, but I'm a little confused. You have to take a pretest. Why is the pretest being turned over to the parole officer? Do you know? That doesn't seem to make the pretest is just supposed to set you up for the actual test.
Can you hear me? Or
we hear you fine.
Mm-hmm. So the way it's explained to me is that I talked on the last about the HIPAA thing with closing off my thing, and so actually, now that I'm taking the test, I asked about it, and they said that the pretest is to make sure that anything that needed to be disclosed prior to the test is being disclosed so that the test can be accurate. And parole having that open line of communication with treatment that's unmonitored due to the other parole condition, they're just getting all that information. It's being transferred straight to parole.
Okay, and you're saying, so presumably you've done something to violate the parole conditions, which is why you're worried about the pretest, and therefore... No.
Well, I haven't personally, but I have other people in my group who are afraid to speak because they want to get the help, but treatment's not going to help them. They're going to turn it over to parole, who's going to violate them.
I mean, I completely agree. I feel like it's like asking... I'm in good standing. My opinion, and I don't... this is just my opinion. I feel like they're forcing you into a confession, not even giving you the opportunity to have an attorney present, which is, you're right, if they're kind of forcing you to those people who have violated the parole conditions, which could cost them an arrest and whatnot. I mean, I agree that you have a right against self-incrimination. I don't know what they would do if you pled the Fifth and said, I have no duty to answer these questions. Or if you requested counsel be present, I don't know if you qualify for the public defender. Or if you can find like a civil attorney who can get a temporary injunctions on these pretests that are going to force people into saying something that's going to get them rearrested. I mean, that does sound completely illegal to me. I think you should bring it to the attention, or somebody who's going to be caught up in the trap of making an admission that's going to get them arrested should find an attorney in Minnesota who, like a civil rights attorney, and talk to them and find out what that attorney can do to help, or what advice they would offer as far as pleading the Fifth or just not answering. I don't know what the ramification would be for doing that. I don't know if I don't know what they would do. They'd say you're not qualified to take the test.
It would probably be a violation.
Pardon me?
I said that I was told that it could result in a violation because my parole conditions say that, well, all of ours do. They say that we have to comply with the polygraph given by treatment if demanded by parole.
Right. So the so the pretest isn't really a pretest. It's a polygraph. I mean, it's just one that's aimed at trying to find out if you violated parole. The other one is aimed at treatment, correct?
Yes, the treatment questions are only on the polygraph. The pretest is just like a question and answer. They want to know the question
it's not a
and then the answer, and then.
Oh, okay.
No, but what they do is they ask a question during the polygraph, like, have you been honest with treatment? And so once you fill out that paperwork, if you lied on that paperwork, it's going to show up on your polygraph. But if you didn't, then you're basically outing yourself.
Yeah, I mean, it does. So the pretest is just a questionnaire, and you have to write down the answers to the questions about whether you violated parole.
Yep, and it's a treatment disclosure, and then they ask a question during the polygraph if you've been completely honest with treatment concerning anything that should have been reported or something along those lines.
Okay, and so the answer would be yes if you pled the fifth and said, I have a right against self-incrimination, and you're saying if you wrote that, you found out that would be a violation of parole because that's not legal. Well, I don't think that's no. They can't well, not in my opinion. I'm not qualified to help you out there, but I would certainly talk to an attorney.
If you can find the resource that's
well, I know somebody maybe he could speak to. Professor Janis, he's in Hamline. I don't know where you're located, but Professor Janis, are you aware of him, Larry? Pardon?
I've actually spoke to Mr. Janis. He was trying to help me with the residency restriction. He put me in contact with Miss Nichols in Illinois.
Adele, but he's out there in Minnesota with you. Right. Have you talked to him about this specific issue? Because
no, but I could probably get in contact with him.
I mean, I think you should call him. He's just opened up a sex offender constitutional legislation institution. I know he's connected to people who, are focused on these issues. So I think I would probably start with him or try Adele again. This could be a good issue for Adele and Mark. They bring lawsuits in other states.
So much.
Yeah.
Thank you for the question. We're going to go to my favorite peach state of Georgia. You're on. What is your question?
Hi, I'm on probation in the state of Georgia and as a sex offender. And one of my probation conditions, and it's kind of a boilerplate probation condition, is that I can't go to a movie theater before 8 p.m. And I'm an avid moviegoer, like going to the movies, and had no problem complying with this in my previous county. And I've since moved to a new county with a new supervising probation officer. And this new probation officer says, well, I really don't like that after 8 p.m. thing because that's when minor children generally go to the movies is after 8 p.m. So I'd rather that you catch a matinee and you go, while school's in, 11 o'clock, 12 o'clock. And so I'm kind of in a rock and a hard place. If I comply with her wishes, I'm not complying with the court order of my supervision. But if I don't comply with her wishes and comply with a court order, I'm going after 8 p.m. and she's not going to be happy. So can she do that, go against what the court order says, and what should I do?
I love that question. I'd like to take a stab at it after you do.
I mean, I think that the court order is what trumps, although most of the time court orders give complete discretion to the parole officers. But if yours doesn't say that, and your court order specifically spells out, all of the terms, then you need to comply with the court order, in my opinion. And I don't think she has the authority to go against the court order. Like I said, unless it says, the parole officer can set terms or has discretion to do X, Y, and Z. That's my opinion. You could also contact the clerk of the court where that issued the order. I don't know. I would be governed by the court order if it were I.
So, well, it's an interesting question because violations of probation are normally initiated. The judges very seldom run out and sua sponte on their own motion seek revocation of an offender. It has happened, I think, once in my career. I've seen it where the judge ran across somebody violating probation, but it doesn't normally happen that way. So if the PO wants you to go at a different time, it seems unimaginable that they would file seek a revocation But on the other hand, the court order is clear that you're not supposed to do it. So what would happen if the probation officer played dirty with him and said, and then denied that, and said, I didn't tell him that, and he's clearly violated. I mean, he really is in a conundrum here.
I mean, I think what you need to do if you want to be compliant with her wishes is go get a new court order. You know, you have to get the court to amend the order so that you move the court to amend the order so that it says that you can only go to the movies.
What county is your case in? What county were you
My
convicted
case
in?
is out of Forsyth County, but I'm supervised in a different county,
What county you're supervised in?
Gwinnett County.
Okay, so he's got an interesting dilemma since I know Georgia so well. He's coming from his conviction county. It's one of the most right-wing counties in the state, and he's in a metro Atlanta county that's becoming a lot more progressive because of the diversity in Gwinnett County. It's becoming a very cosmopolitan, diverse county, quite large. I think it might be the largest or second largest county in the state now. So, of course, they don't have any control over the Forsyth County people are going to be ones that can modify your court order. So it's interesting. I would think that the court would defer if the probation officer wanted that condition changed. I would think the court would be more than happy to change that. If that's what the probation, because the court's not the specialist, the probation officer is. So I would agree with the counselor that you would go ask for clarification and get the court order modified out of Forsyth County.
Sure, I should be very careful about following her wishes and deviating from the 8 p.m.
I would not do anything that you are not permitted to do by court order. The court order is the final word on your probation terms unless it has something in there that says, terms set by a probation officer or at probation officer's discretion to change them. If it doesn't say something like that, then the order is what governs your actions, not the parole officer's, wishes that compete with the order. So yeah, I totally agree with Larry. I don't think the court's going to have any issue or the state's attorney is going to have any issue with changing the times when you're allowed to go to the theater.
So
it should be simple.
Thank you very much.
Hope that helps you. Thank you for the great question. So we are going to move on. This is area code 276. You're on Can They Do That?
Hi, this is Tammy Lawson, and I'm from Virginia. And my question is, I've been listed as a violent sex offender ever since 2003. In my plea or in my agreement, there was never no terms or conditions set out before me. And I didn't have any knowledge thereof until a few years ago when I started searching this stuff out. So I'm just wondering, as a Virginia registrant, is there any way that I can get off this lifetime registration outside of what the law says?
I'm sorry, outside of what the law says? Is that what you asked?
Her question is that. I was going to rephrase your question, but I'll give you a shot at making it sharper.
Okay, making it sharper would be I have to register lifetime, and in Virginia, under the code and statute, there is no way that I can ever come off the registry. So, since I have been clean and free for 13 years, is there an alternative method that I could go to fit myself in society normally, get relief?
Not that I'm aware of. I mean, the statute, if your crime subjects you by statute to lifetime registration with no ability to petition to get off, no, you won't be able to petition to get off. I mean, the only vehicle I see for lifetime registrants to try to get off is to challenge the statute making certain crimes or throwing anybody designated as a certain thing into the lifetime registration box to try to get that particular statute in Virginia declared unconstitutional, which is a very difficult task to achieve. So I don't mean to sound hopeless, but I don't think so.
I will give you a couple of other. I'll give you a couple other possibilities as well, and that you might want to consider. That the executive clemency may be a possibility. It's seldom granted, but it has. I think I've seen a case or two of it. So that's a long shot. That may be an option in Virginia. I don't know the law there. And then remember, since sex offender registration is a civil regulatory scheme, you're governed by the civil regulatory scheme of the state you decide to live in. So there are lifetime obligation. Virginia doesn't control you when you move to Vermont. Virginia can wish that you had a lifetime registration in Vermont, but they don't have any control over that. They might keep you on their website in Virginia. I can't speak for that, but that's not the same as having you come into the registry office and fill out paperwork and have your fingerprints made and be told that you can't live within a certain feet, or you can't work here and you can't work there. So you could possibly be on a website, but that is nowhere near the same as being registered. So there might be those options as moving to a state where your registration period would be shorter. But we don't have that list. We don't have that list.
Okay. I just wondered, as being a mother, having a son who was 14 at the time, he's now 29. He had consensual sex with a female while in master's custody, and I got charged for failing to properly tell them about it, or allowing him or encouraging him. So I don't even know how I ended up on the registry anyway, and I have new evidence. But how could I go about giving that to the court now that I took a plea, or could I, or you don't know?
The evidence is not going to be helpful.
You're saying that
Go ahead.
Yeah. Well, the crime that you were convicted of is classified as a sex offense?
Yes, ma'am. They put me on a registry for reporting it. I reported the crime of my 14-year-old son having consensual sex with a female, but they charged me with not failing to maintain or have control or supervising the child and not reporting it in a timely manner. So it was under the indecent liberties where you allowed or encouraged or knew about it.
Wow. I mean, I just say it's a really strict state. That sounds awfully strict. It seems like it's a disproportionate penalty for the crime, that is a constitutional challenge. It seems like as applied to you and your situation, the lifetime registry seems to support disproportionate. Your conviction is so old, you can't, it's a criminal charge. Your time for challenging these things expires.
So I was going to say her new avenue. I mean, the plea is foreclosed practically every avenue but she's got a unique circumstance that
guilty pleas don't foreclose constitutional challenges.
She was talking about bringing in new evidence to attack the plea. I've argued that with constitutional professionals and the Supreme Court just agreed with me a few weeks ago that you can mount a constitutional challenge. But going back and with new evidence in terms of this offense, those doors are pretty much closed. But she's got a unique opportunity. That executive clemency may be something that would be considered, and here's you don't want to do both. You don't want to file a constitutional challenge and executive clemency request at the same time. Most of the time, the executive is not going to look kindly on that because clemency are usually from someone who has paid their debt to society and they feel bad about it and they want to move on with their life. And so you might be advised to do one or the other, but not both.
And given that it was 15 years ago, I would suspect, without knowing, that there would be plenty of states that you could move to where you would not face a registry requirement for that crime at this stage. Of course, nobody wants to pick up and move, but it would afford you probably more freedoms in your living circumstances.
So
thank you.
So talk to someone about executive clemency in unique circumstances, and then see if they think it's just a poo-poo that would never happen in your state.
As far as clemency, you can contact the American Bar Association because I think that they have a pro bono program where attorneys they volunteer to do exclusively like these clemency things on their spare time, not for sex offenders alone, but for a variety of crimes.
So we have Professor Vanderwall did you have something you wanted to add to the comment?
Yeah, I wanted to add to the caller that in Virginia there is such a thing as what's called an ends of justice claim. So that, and I don't want to give any particular advice because I can't be certain that it would apply in this situation, but I do know that in the past there have been challenges brought under that theory, under essentially the style of the complaint is that the condition imposed, or that I have a grievance that I can't find any relief for, and so I'm asking the courts to provide relief under an ends of justice sort of scenario where you're essentially saying, this is not right, and can somebody please take a look at it? So you might want to explore that option in Virginia. That's a claim unique to Virginia.
So I had no idea. So we'll leave you, if you're going to have a quiet background, we'll leave you unmuted so you can jump in here if you need to. So thank you for that.
Okay.
So we're going to go back to the Tar Heel State where we've been before. So what's going on in the Tar Heel State? You're on. What's your question?
I really feel sorry for the person in Virginia. I'm still taken aback by listening to that. However, the question I had was, when does the 2011 cutoff date actually occur? And does that apply to Illinois, or does it extend federally? My other question is, you lost, well, I don't think you lost the case yet, but you had some setbacks in the case. It seems like the Supreme Court is violating its own de novo standard, or an issue with Huddleston versus United States regarding prejudicial evidence. If the courts rely on false or misleading data, does that imply an argument that perjury or an introduction of false testimony is acceptable? I mean, the courts are our closest allies at reducing the politically laced rhetoric. So what's being done to introduce unbiased or trustworthy data before the courts?
Well, they had unbiased and well, to start with your initial question, the 2011 cutoff, I believe it was July 1 of 2011 that the statute came on the books. So any crime committed prior to that date would be benefited by a win on the ex post facto clause. The justices had a ton of data and statistics in front of them, both in the briefs and at oral argument. They mentioned only a couple of the statistics from a whole grouping of Bureau of Justice reports that are very comprehensive. And they said, although, I mean, they acknowledged that the social science was convincing for Pepitone's argument, but they said we're not a super legislator. So they just shirked their responsibility of kind of actually performing rational basis review. The only recourse for what they did is to try to appeal it to SCOTUS, but to the United States Supreme Court, again, like I mentioned, there's strategizing that's going on regarding the way to frame the issue, and whether, if we were to appeal it to SCOTUS, to sort of try to ask the United States Supreme Court to step in and say, well, when we're dealing with legislation that specifically targets a class of people, it's like label-based legislation, which is essentially is predominantly sex offender legislation. These really hated minorities, shouldn't rational basis review be heightened to a higher level of scrutiny? Because when you are making a substantive due process claim, as was the case here, rational basis review is the standard. But if we want to make a substantive due process claim for when the legislation isn't targeting everyone, but just a specific hated group, shouldn't the standard be elevated and heightened? And anyway, I don't want to get in. We can have another call as decisions.
No, that's a fair answer. I thank you. I'm trying to learn how the court thinks, so that I can be a better advocate.
Well, the Illinois Supreme Court was just that. Here's how they think, in my opinion, and they are elected officials. What was interesting to me about the decision is that at oral argument, at least two of them, and arguably three, seemed really disturbed by the statute, based on the tough questions they were giving the state, and I would have thought that at least one of them would have dissented. Just based on how terrible the reasoning in the decision was alone, or filed a separate concurrence, because to put your name behind that opinion that was released, it's shameful.
Agreed. I mean, that's going to be a large dilemma as long as justices at the state level are elected officials.
Well, right. Absolutely. That's why, Mark, I don't know how familiar you are with attorneys doing stuff with these statutes, but that's why Mark and Adele, I think, take all of their cases to federal court where the judges are appointed. There's kind of a better shot there. But when it's a criminal case, you don't have a choice of taking it over to a federal, when it's a state criminal.
Thank you for your hard work. Thank you very much for your hard work.
So
you're very welcome.
Are you a legal beagle? The caller?
No, I'm not a legal beagle. I'm a public policy analyst, but I am. I want to be an advocate, also on the registry. But that's what gave me the fire to do what I'm doing now.
It seems like you're deeper into this on studying and your analytical skills than a lot of our people. So I just wanted to note that. Appreciate your questions.
That's all right. I appreciate that. Thank you.
So we're going to go back to area code 202, I believe. Well, I forgot what area code that is. I think that's DC, maybe.
I think so.
We tried to get you on last time, and we didn't hear anything. You're on. Go ahead with your question.
Okay.
We got you
How
there.
about
Stay right where you are. Do that.
There we go. I am a registered sex offender in Baltimore, Maryland. And my question is regarding a sting operation where the official, this time out of DC, is posing online as a sex partner for gay males, and then once he has agreed to have sex with me, he then says, oh, by the way, I have a minor that I have an ongoing sexual relationship with, and would you mind if he joins us? That is not the same entrapment as posing as a minor.
I, quite frankly, am not familiar with this area of law, and I was on the call earlier, but I was doing some typing and researching, so I didn't hear much of what King said. So I don't know, Larry, if King said something relevant to this, or if you know something about it.
Well, with the just information the caller's giving, assuming that the detective was of legal age, they were setting up a rendezvous, and then the minor is mentioned by the detective. It would be a very troubling situation for the detective to bring up the fact of the minor, that he wants to, that he initiated that. So I'm assuming you took a plea. Is that correct? I'm assuming you took a plea.
Yes, I did take a plea for 7 years.
So factually, whatever the indictment or information, when they did the allocution of responsibility, there were certain factual representations made that have you kind of boxed in on this, because for the court to accept the plea, there had to have been a factual basis presented. And a lot of times the people are so nervous they don't have a clue, and you have to pull the transcript and see how the factual basis is built up. But the fact that the matter is that there was a solicitation for sex as far as the court's concerned from a minor of some type, and you have agreed that you did do that. So it's a real long shot now. And how long are we talking about that this happened?
Oh, I was arrested in 2011, and I've been out for about a year. And I write an article actually in the NARSOL newsletter for people getting out, soon to get out, called Outward Bound.
The
point of my calling in is to flag the detective out of the D.C. police force in conjunction with the FBI posing online and proactively seducing, subjugating, promoting, soliciting men to behave in a way that they wouldn't normally do. And his name is Detective Palchak.
So I have a little concern about what I mean. I appreciate what you're doing, but I have a little concern because we don't have him here to respond. So I try to be fair.
But you find out in the court, but you find out in the court he's done, incredible things to entice, pull in, lie, basically. But these people get away with it. And it's not the same as hanging out, acting like they're a 12-year-old girl. He is going into websites specifically to entice people to come on to him and then present the minor.
So we will.
It's terrible if they consider that in your plea deal.
So what was he doing online to begin with?
You were still. It's terrible conduct on his part, and it's unfortunate. But it's like it was your choice to agree to his request, even though you typically wouldn't or seek that out yourself. But I don't really see much of a defense.
I understand that, but if I was going after the guy, if I was approaching another adult to have sex and then he introduces the enticement.
Right. So, I mean, I don't know if that if they considered that in your plea deal.
So what was he doing online to begin with?
Well, he was trying to set people up, like you up to, but he's not. As far as I mean, that's not illegal.
That's not illegal to pose as something, that you're not.
I frankly, I told you from the outset, I am not terribly familiar with this area of law, and I missed the first portion of the call.
Right.
So I don't know if you were on the first portion. Did they cover this at all?
Not this exact scenario of I mean, we did discuss the predisposition and the inducement. If the law enforcement officer does the inducing and the initiation of the idea of the criminality, you have a potential defense. But I'm assuming you had an attorney. You didn't go in and represent yourself pro se. You did discuss this serious charge.
I had a very expensive attorney in Washington, D.C. And there was no doubt that there was no enticement.
Well, for some reason, your attorney recommended
or entrapment.
For some reason, your attorney felt it was the best course of action. So this is something where we would have to dig a lot deeper than we can dig in this particular phone call. But I am interested. I may call you. I may call you and discuss this further off of the program because I got more callers in the queue. But But I appreciate you bringing.
But I just want to bring that up. And thank you for your time.
Thank you very much. So we're in lightning round now. We're going to go to area code 217 for a quick question.
Hello.
Yeah, go ahead. Yeah, go ahead with your question.
Yes. Yes, I was listening earlier. I don't know quite how this technology is supposed to work, but I am on right now I'm on a cell phone. I was listening to some headphones, and I just pulled it off to be able to ask the question.
Go ahead.
My question has to do with the classification system that seems to be, I don't know, in so many places. My case was federal, and it was down in Florida. And then when I got out of prison 7 years later, I moved to Illinois, back where I was born and raised, and registered here because they don't have SORNA here. They just have their regular state registration system in Illinois. But they have a classification system that says that if you've got a lifetime registration requirement, they call you an SVP. And my crime had nothing to do with that. My crime basically was journalistic curiosity. I'm a writer and I've been published a lot and stuff. But they can do a real job on you, Spanish Inquisition style, for the public defenders. I've had two public defenders that just threw me right under the bus.
So we're going to have to stop your question. We've got your question. So we're running out of time.
The question.
If the question
is automatically bump you up a tier or two just because you have a lifetime registration, which everybody gets nowadays.
We don't. Yeah, Illinois doesn't have a tiered system. I mean, the tiering to an extent is just whether the duration of the time on the registry, but it doesn't tier the offenses. Like it's, you're not like a class 3 because your crime isn't that bad, but a class 1 because it's terrible. We don't have that. And we might, that's been proposed. But if your question is, you said that you are designated as a sexually violent person under Illinois' SORA because of your lifetime registration requirement on the federal registry because of your Florida conviction. Is that correct?
He can't hear you anymore. We're running out of time.
Well, if that is correct, I mean,
he can hear you, but he can't respond to you.
I know that Adele and Mark recently got an issue brought to them from this Michigan attorney where somebody committed a crime in Michigan, but on vacation, their business is from Illinois. Crime, if committed in Illinois, would cost him 15 years on the registry and would not cost him the designation of having all of these criminal statutes apply to him. However, Illinois' Sex Offender Registration Act has this tiny little section that says if you are convicted of any out-of-state crime, if you have a sex conviction from any other state, then it's automatic lifetime registration here. Well, that doesn't make any sense. And so they're going to be challenging that, I believe, as far as I know. And if this gentleman's situation fits that set of facts, it might be perfect for him to join that lawsuit, which is in the works now, as far as I know. So I would recommend, I mean, I'm not totally clear on his issue, but I would recommend him getting in touch with one of them.
So thank you for that. And we're up against the clock here, and I'm going to tell you that we really appreciate you coming in and giving your hour to us.
Oh, well, I appreciate you inviting me, and I'm happy to be here.
And we will be using your skills again. And we're glad to have you, and we're looking forward to seeing you in Independence.
Yes. Okay. All right. Well, thank you, Larry. I will sign off then.
Well, and we're going to come back we're going to do a few more minutes after the top of the hour break. There's still a few people in the queue. And if you just want to talk to the old host, we'll take those questions. And if those of you who don't want to talk to the old host, you could just go ahead and drop off of the call. So, did you have anything else? I don't hear music yet. Did you have anything else you wanted to say before we break regarding your?
Well, regarding Pepitone, I would just say this is far from over, and it's my mission to get the entire statute struck down. So let's hope that it might be a possibility, and I'm hoping it is, and that's what we're doing with Pepitone.
Well, we're going to be with you on that. So,
okay, Larry. All right.
So we appreciate what you've been doing, and we hope that we can be your partner in all of your endeavors as the challenges unfold in Illinois.
I've got another interesting one to tell you about too, but we'll talk next time.
So thanks a lot and good night, and we'll see you guys on the flip side if anybody has any more questions. So we'll be back in a few minutes.
Okay.
Child sexual abuse is declining. We've had a 62% decrease in 1990. In 1990, about a quarter of children reported abuse. That's up 50%. These laws are an invitation to discriminate, harass, and even physically attack registrants. People on the registry become suspects for life. If your driver's license says sex offender on it, that's an open invitation to profiling. This is just punishment for the sake of punishment, punishment on top of punishment. Remember, people with a conviction record already face nearly 50,000 federal, state, and local legal restrictions, collateral consequences. We don't need more.
Are you tired of hearing what feels like gloom and doom all the time? Tired of the message that there's no hope? That somehow life is over? Humans on the Registry, that's humans.narsol.org, has been launched with the goal of sharing some positive messages about registered persons. This project of the National Association for Rational Sexual Offense Laws seeks to bring a little light and hope and humanity to this difficult subject through short stories about registrants who are succeeding in spite of the obstacles in their paths. Are you a registered citizen who has a positive story to share? Have you found meaning, a better tomorrow, a loving family, built a new life? Come tell us about it at humans.narsol.org and show the world and other registered citizens that we all have reason to hope.
Welcome back, everyone. We're now in the overtime component segment of the program. So I invited everybody who didn't want to ask me a question to drop off, and most of them did. So those of you that are remaining, if you have any other questions, you can hit *6. And otherwise, I think we've cleared the waiting list. Andy, look at this. Fantastic. They're all gone.
Don't take it personal.
Oh, I don't. So I just want to give people an opportunity. If anybody had any other questions, we should go to Mississippi.
You do have one in the queue.
Well, yeah, there is one. But I just wanted to say hi to Mississippi and thank you for all the work you do for us. He fell asleep.
That's me. That's King. I unmuted my mic. Well, I enjoyed the second half of the show with Catherine. Can you hear me?
We hear you fine.
Yeah, that was pleasant. I know that questions and answers went longer than you would have liked, but I think overall it was a good production.
Did you have anything to add to that caller that was talking about the entrapment, the inducement?
Yeah, while he was talking, I was looking at just to see what somebody else said about entrapment, and there's this NOLO.com legal encyclopedia. It has entrapment basics. And there's two standards. California is an objective standard state, and in which entrapment is a defense if conduct by law enforcement agents that would likely induce a normally law-abiding person to commit a crime, induce the defendant to commit a crime. Florida is a subjective standard state, and they say that the defendants who allege entrapment have a burden of proving, which is weird that defendants have to prove anything, but by a preponderance of the evidence that a government agent induced the defendant to commit a crime charged. And that's similar to what I was saying. They give some useful hypotheticals. Examples actually. And the things that don't amount to entrapment would amaze you. It's like Mary Ann Berry's charged with selling illegal drugs to an undercover police officer. She testifies that the drugs were for personal use, and the reason she sold some of the officers is that at a party, the officer falsely said that she wanted some drugs for her mom, who was in a lot of pain. And she says the officer even assured her that she wasn't a cop, and she wasn't setting her up. Conclusion, the police officer's actions do not amount to entrapment. Police officers are allowed to tell lies. The officer gave Berry an opportunity to break the law, but the officer did not engage in extreme or overbearing behavior. And that is how they defined it. It has to almost be coercion, extortion, overbearing coercion, and other overbearing tactics to induce someone to commit a crime. So that's more or less what I said, is that it's very difficult to show that if they just present, even if they use a lot of persuasion and subterfuge to get a person to commit the crime, including, causing people to form what feel like real emotional attachments.
So, well, King, so let's take his scenario at face value. He's in a forum where he's talking to what he thinks is a hot adult man.
Yeah, and then it's a kind of a bait and switch. Oh, can I bring my underage other partner in with us for a threesome? And he really wants to be with the guy, so he says okay.
Okay.
No.
Okay.
No. Yeah, go ahead.
Oh, that was the inducement of the guy has no predisposition, assuming that everything he said is true. He has no predisposition to have sex with underage. And the officer says, I can really hook you up with something good. We do it all the time. That would seem like something where the juror would be sitting there saying, well, I find it repugnant that he said yes, but why don't they find it repugnant that the officer made the offer for something the man wasn't looking for?
I think the answer is they probably do find it repugnant that the officer made the offer. But are they willing to engage in a jury nullification because they are so repelled, like, Johnny Cochran in the O.J. Simpson case saying, we need to send a message that this racism that these police committed, and basically cut this football hero free, and which is what they did, but that was, a unique set of circumstances. I think that even though they are repelled by the police tactics, most jurors, in my experience, and which is a lot, are going to come down on the side of it's just not okay to acquiesce and say okay to engage in sexual relations with an underage person. Nobody held a gun to your head.
So it's like the men that I talk to that are in the chat rooms when they say that the person changes their age. I say, well, you're supposed to say at that point, to hell with you, I don't want to talk to you anymore, but nobody does, because the officer is telling them, you don't love me. I thought we had something going here.
Person.
The officer,
yeah.
And of course, if you have a heart and you think that this might be, because they'll paint a picture of an abused child. My dad is a dickhead and he drinks all the time and he beats up my mom and I don't have anybody to talk to.
Yeah, and you made me feel like I count for something, and you're the only person ever has, and you don't want to be with me, and And then now I feel like I've got nobody else who's going. I'm afraid I might harm myself if if they started saying I may commit suicide, then the jury might say, wait a minute, So I took it a step further on your hypothetical, but. Just on the other stuff, that they expect adults to hold firm. We do encounter temptations in life. And they might say, well, you're lucky the person revealed themselves to be underage before you did anything or before you tried to set something up. Because the way the law is written is that you go on and do something. Lack of knowledge of the defendant's age is no excuse. And I think that's terrible because they can get perfectly official-looking fake IDs, and that's not a defense. I would try to get a jury nullification under those circumstances, but the way the law is written, it's not a defense.
Well, the queue is filled up again, so let's take them, King. Do you want to have a little more fun?
Oh, they're still on?
Oh, yeah. So let's do it.
Yeah, I'll talk to some more, but I didn't know you had any more.
Eric 0218, you're on. What is your question?
Hey, so I've actually talked to Adele and Mark, and I'm thinking about challenging our tier system. We call it a level system. The way you get a level in our state is you have a panel of 5 people that include a prison worker, a psychiatrist from the prison, a local police officer, a crime victims' right advocate for the crime that you committed, and there's another person there, but none of them are licensed to make a psychological decision except for the one. So you can receive a level. They go off of a MinStat score, which is a scoring system that's supposed to tell you what your recidivism rate is. And they give levels that aren't necessarily based off the score. So for me, I was scored as a 2, but given a 3. My question is do you see legal ramification to be able to challenge the system based on the fact that the Department of Corrections gives you a level and then also reviews for level reductions, and the people who originally give you your level are not qualified to make those decisions?
This is King, and the question is for me. Is that right, Larry?
Yes, that's for you. I don't think I'm qualified to touch that one.
Yeah, and I hardly am myself. I'm licensed in Louisiana, and once you're in your tier level and the time for challenging it has run out, there is no procedure for changing it.
What state are you in, caller?
This is me in Minnesota again. I'm actually still on parole, and I can challenge my level every 2 years. I'm actually about to challenge it, but they told me that the likelihood of a challenge being won is not very likely unless the parole agent will come out and say that you no longer pose the same risk as a level 3 would, and no agents will put their reputation on the line to say that. So it's very hard to get a level 3 reduced to a level 2.
So what state did you say? What state did you say you're in?
Minnesota, he said.
Minnesota. Okay.
I successfully got a man from Minnesota off the sex offender registry, and when I speak on this to lawyers groups for credit, I tell them that even if you get somebody off death row, it's probably not the jubilant situation. It's well, maybe it is, but I mean, if you ever want to see a client actually jump up and kick his heels together, get him off the sex offender registry. And I was able to do it for this man, but he shouldn't have been on it in the first place, because what he had in Minnesota should have pigeonholed in Louisiana as a non-registration misdemeanor sexual, misdemeanor carnal knowledge of a juvenile. He was a stonemason and had to follow his work, and he had gone to Colorado, and simply because Colorado made him register. And then Louisiana made him register simply because Colorado had made him register. Yeah, and he had the Colorado ID and everything. And so I read about how to, and he had been in Louisiana a long, we had time to deal with the classification, the tier designation. We were in that phase of things for him as a term, but it came to my attention because he had been charged with felony failure to register because of a non-updated ID. And the prosecutor had actually changed, or he was arrested for failure to register, which is a mandatory minimum of 2 years, 2 to 10, hard labor felony. But the prosecutor only accepted it as a failure to update, which I thought was a misdemeanor. But the prosecutor, oh no, it's with or without hard labor, so it's a felony. But even though it only carries up to 6 months, which is pretty much what defines a misdemeanor in Louisiana, is anything 6 months or less, unless then it's a Duncan misdemeanor. If it's more, you get a right to trial by jury. But I was able to go back and get in touch with the clerk of court in his county from just reading the statutory law. And fortunately, in Anoka County, Minnesota, they automatically transcribe what happened in court, which in Louisiana you would have to, they have the recordings, but you have to pay a court reporter and wait, for them to transcribe it. But they already had it, and I got it very quickly, and I was able to provide it to the Louisiana. It's under the state police, which is under Department of Public Safety and Corrections, the Bureau of Criminal Identification and Information, and they looked at it and they said, it's the way I found out about it is he simply got a phone call from the sheriff deputy who supervised registration, said, okay, you're off the registry, you can go to the driver's license branch and get an ID that doesn't have sex offender on it now. And my prosecutor said, well, that's not enough for me, I need a document, I need something for my file. So we were able to get that from them, and he was off the registry, and then the felony charge was dismissed. But what you're talking about is you have a system in Minnesota that you can review. That is what the U.S. Supreme Court kind of indicated that in Packingham versus North Carolina, there's this parenthetical paragraph in which they say, we find it disturbing. I'm paraphrasing. We just find it disturbing that these people are subjected to these onerous things after having completely served all of their sentences. But that's not before us, and blah, blah, blah. But it was kind of a strong indication that the majority, at least, thinks it ought to be individualized. It sounds like in Minnesota, to some extent, it is individualized, but you have the same problem there you have here. Just like we have people who would like their counseling to end, but no counselor wants to go out on a limb and say, I don't think this person is a risk anymore, because they're all afraid. For one thing that Larry identified previously, it's a cash cow. And it's a racket. But then the other thing is they're worried about their liability, either civil or political, and in terms of getting more of this work, is if they give someone a clean bill of health and then something bad happens, and then it destroys their livelihood.
So another point he's making, and then I'm going to move on because there's people waiting, but the point he's making is that the people that make the initial classification are not necessarily in the best position, and then there's this extreme deference to their decision because they're trying to overturn an original decision. It's kind of like I tell people about agency law and the standard, the deference to the agency. So the corrections department makes the determination that he's this risk level, and then he's stuck in that because of the deference that's afforded the agency's decision. So it's a tough. He's in a bad situation. So hopefully he can find some competent legal counsel.
Yeah,
so,
well, at least he has the opportunity. Here it's foreclosed after so long a time. If you don't appeal it administratively, and it is under the Administrative Procedures Act, so all that deference applies. If you don't appeal it administratively within 1 year, and many people don't even have counsel at that point, they don't know that they should.
They're not even out of prison in the year.
Well, I mean, the registration
in his case
only starts after they're released.
So.
But then once that year's up, if they have appealed and the appeal is denied, then it's under regular, in district court, regular appellate delays, which is like only 30 days. And a lot of people thought that they had the entire time of their registration to find something wrong with this or that they're in the wrong tier and so on. Not so here. It's permanent, but it sounds like he's got something that's individualized. And here it's strictly based on the offensive conviction, and that is immutable.
Minnesota, it's not that way. So he has a risk-based system that's done a little bit more objectively. I think that the area code 202 was the caller that had the question about the sting. So I'm going to bring him back briefly. So if that is you, you hang in there because we see you. The volume of people have dropped enough. So, but I'm going to take this one in the queue first from Pennsylvania before we go back and see if that's the guy from the Sting. So, area code 484. I think you're in Pennsylvania. Go ahead.
Yes.
Go ahead.
Thank you for the show information. Two quick things. One, you referred to a Professor Janice who is doing something in a law school advisory capacity that's sort of friendly towards our point about the reconstruction of the sexual offender law. Is that true, or are you aware of any law schools that not will give you an amicus brief, but we would be able to keep you in the legal channel?
Is the question for me?
And then,
okay, is there
anyone,
more to it?
And then, well, no, I was going to go on to just no.
Okay, well, I can tell you, I don't know if there is a dedicated clinic at a law school or university. I should hope so, but I do see very favorable law review articles coming out in criticism of the system that we have now, the prevalent system that we have now. And even the most progressive of the systems is still woefully inadequate in terms of liberty and due process and rationality as far as meeting any of the goals that they profess to have. We have a long way to go in advocacy, but yes, there are people who write about it from a critical legal point of view. My point of view in Louisiana, and also of the former, I don't know who they have now, but the former executive director of the ACLU of Louisiana was Marjorie Essman, and she and I did a lot of talking about this. We were in complete agreement that there's no point whatsoever in challenging any of these laws in the state courts of Louisiana, because our judges, from the district court judge at the trial level, the intermediate appellate judges, and the Louisiana Supreme Court, are elected, every last one of them, and they all want to keep their positions and move up and retire at the highest salary that they can draw. What you want is an Article III federal judge who is life tenured, who can only be removed for disability or impeached for high crimes and misdemeanors. And they're high quality, they have good law clerks, and they're secure in their positions, and they actually dig into the law and apply it. So that's the only place we would be interested in the middle district of Louisiana, is where the capital is, and that's where these things have to be challenged. We have 4 good federal judges there that any one of them would be okay. But we're really in the process right now of outreach to find civil litigators for impact litigation who do federal civil litigation, 42 U.S.C. 1983 actions, state action, and to challenge these things where there are statutory attorney's fees available. And we're in the process, but I'm getting more and more noise from the general criminal bar that they have clients who want to challenge these things. And so I'm very hopeful we'll be able to come to NARSOL's Scarlet Legal Action Project with some good prospects, some people to litigate this, and who want maybe some cooperative endeavor agreements, risk sharing on expenses, and I'm anxious to provide them templates, and if they want us to feed them plaintiffs, we have a lot of them, and so on. We're ready to go. It's really, people are getting impatient.
So, well, King, the door is open. The offer is there. We've got a small nest egg that we do want to partner with.
And I'm telling them that, yeah.
So
maybe something will break soon.
And the area code 202 caller may have not been the same person, because they appear to have vanished. So if you are there, please press *6. so we can get you back on.
And this was the gentleman about where the officer pretending says, "Well, I want to bring in a third party who's a regular partner of mine, and by the way, he's underage."
Yes,
is
and
that the one?
It may have, yes, that was the one, but it may not be the same person, and they've since departed. So
okay,
if there's anybody else who has a question, you better do the *6 because we're about to sign off for the night. So believe it or not, King, there's actually still 24 people here, and I don't know how many on live stream, but yeah, it's been a great call, and the offer that we have is a cost share, and we do try to come up with a case that has a very strong probability that the claims are sufficient enough that we could succeed. And we look at the viability of the case. Some people feel like you should just sue because it makes you feel good, and that's not a good strategy. But we would like to be a part of litigation. And in fact, one of your colleagues in Louisiana got in touch with us just in the last few days. Let me see if the name is escaping me, but she knows you.
Okay. So a female. That's interesting. Okay.
Yeah.
Well, some names have been mentioned on the defense bar has a listserv, and different lawyers have said they're doing things, but I don't remember one being a female. But if you have one out of Gretna, Louisiana,
I have one out of Orleans Parish. She's working at the OPD.
Okay. Well, that's bound to be someone I know.
Yeah. So she. And she's looking for a way for OPD to be able to bring some civil actions, and that's what a lot of people have difficulty understanding. That public defenders defend people, and they're not permitted to do civil actions. And she's looking for a way through a special grant that she has, where she's not really directly on OPD's payroll, but she's working within the sphere of the OPD to bring a case. Her concern was the horrendous fees that are associated with public notification. So you pay a $60 fee, as I understood it, and then you have to pay for the notification that's required by statute. And she said that a lot of people are in jail. She said it could be hundreds or maybe over 1,000 that can't pay the fees, and it's essentially a debtor's prison in Louisiana because they'll give them a chance or two to pay the fee associated with notification. But that seems kind of silly to me. The notification still goes out. I mean, do they just not do the notification if the person can't pay the fee?
They do it, but they hold you responsible for the fee, and if you can't pay it, then they charge you with failure to register, which is a hard labor felony with mandatory time. It's just really crazy. And they won't let you out in the first place at all in Louisiana unless you have an approved residence, which is really a challenge. And these are all people who've already been adjudicated indigent. And if you weren't indigent before, and then you try to live in the free world as a registered person, then very quickly you are hammered into abject poverty. And I use that phrase, hammered into abject poverty, on the record of court proceedings as frequently as I can, because it's just true and no one can argue with it. And then they get charges if they can't comply. Plus the whole thing is designed that even a genius can't even figure out how to comply with it. It seems like it's in bad faith to me. But great, I'm glad to know that that they're getting organized about that and maybe getting some grant money to supervise something like that. It needs to be challenged in the Middle District, but Orleans is not very far from that. They're only about an hour from each other. New Orleans is on the phone, but my phone rings all the time, and usually it's just solicitors. So we'll ignore that. I don't know if you can even hear it in the background.
It's a Ms. Jordan. Does that ring a bell?
At the OPD, I kind of I'm better known to most of them than most of them are to me.
That's what she said. She said everybody's heard of that old codger.
Yeah. Well, the name King Alexander's kind of, even if you never heard of me before, you kind of think, well, I think I've heard that name before. But it also turns out that the president of the Louisiana State University system is also named King Alexander. But I was here first. That guy came here from somewhere else. He's bound to be some kind of cousin.
So anyway, we'll be looking at the options of what we might be able to do. And believe it or not, they've got back in the queue
We have
again.
people
So
in the
let's
queue.
just
Okay.
let's just take a couple more. Oh, yeah, they while we were BSing, they came back. I think they've both been here before, but they probably have thought of something else. So 541 up there, and I believe that's Oregon.
Yeah, thanks for taking my call.
Go ahead.
There's language in the statutes of my state that to talk about in terms of establishing levels, about objective measurements, appealing to objective measurements. But then the trump card is also always, well, but then it's up ultimately to the discretion of, CCO or whoever's wherever the buck stops. Are there any test cases that you're aware of with as far as leveling, but also lifetime supervision, lifetime registration, where the statutory language toward objective measurement is strong enough that you think we might be able to undo this culture of fear that seems to predominate, people protecting their jobs, rather than appealing to these measurements that the law at least recognizes to be potentially valid in terms of meta-analysis and measurement tools?
That is the direction that the law needs to go, is individualized and more objectively measured. It doesn't make any this one size fits all, the Louisiana system, for instance, and the one that was at issue in the appeal, the petition for certiorari of Snyder versus Doe, which was denied. The Sixth Circuit case is Doe's versus Snyder, SNYDER, out of Michigan. Similar thing to what we have in Louisiana is that they go by the offense that you were convicted of, and that's it. And if your conviction is from another state, then they pigeonhole it to one that's in their criminal code. And if you don't manage to get it changed before that becomes final, then that's it. Well, that seemed repugnant to the majority in Packingham. I was talking about Snyder a moment ago, but that wasn't the one in which the Supreme Court wrote an opinion. It was actually Packingham, which was about social media. But they just kind of parenthetically made reference to the fact that, whoa, these people have already served all their time and they're subject to this onerous stuff. But that wasn't what was before them in that case. It's what would have been before them had they granted certiorari in Snyder versus Doe, but they asked for an amicus brief from the U.S. Solicitor General, who filed one, and the U.S. Solicitor General was saying, we don't think you need to grant certiorari in this because SORNA, the federal act, doesn't require the states to do this stuff that Michigan is doing that's so onerous. They were probably fearful that the whole thing could be struck down.
Okay. I followed most of that.
He was asking for
it has having to do with the decision-making accountability being fear-based to the point where low risk is treated as if it's more than low risk, and everybody agrees that there's no such thing as no risk. So they err on the side of caution, which is always the side of, no, it's valid to keep you where you're at.
Right, and I think your point goes to, if we had truly non-conflicted decision makers who were truly professionally detached from the situation, who were rendering these opinions, we might get better and fairer results. I agree that's the case. Unfortunately, what we have is people who get contracts to do this. In Louisiana, there's this one fellow in the center of the state in Alexandria, and he's not even a clinical psychologist at all. His wife is. But what he has, he's stacked up a stable of these people and has contracts all around the state, and he's getting $100 a month from each one. He doesn't want it ever to end. He's got himself quite a pyramid there. And in one fellow who I had represented and who was what we call SOAP adjudicated, which is like SVP. And I just ran across SVP is in our statutory law too, but it's Pennsylvania people at the 9th NARSOL conference in Atlanta that I became more familiar with how arbitrary that could be. Is that somebody come in and ask you a couple of questions, and based on that, they're saying, do you think there's a risk that you would ever commit? What do you think your risk is that you would ever commit this again? And the fellow said, well, I told him 0 because I'm just not doing that again. And he said, based on that answer, he decided that I was an SVP, and I'm stuck with that designation now because of the one answer that I gave. Well, that's not very objective, and that's crazy. It blew my mind, but some of the things I encounter here are not much different.
I don't understand why the treatment industry is nervous at all, because if they started sending people to treatment instead of prison like they should in a stair-stepped system, they'd never run out of work anyway. So I'm not really sure where that.
Yeah, and that's for really legitimate people, but you got, universities cranking out people with psychology degrees, and they're trying to find a job anywhere, and you got this guy whose whole object is filthy lucre, stacking these people up and pyramid them so that he can rake off a lot of money. You might have people who would like to do good, but the employment for them is not really available. I think until state governments, and Louisiana will be the very last one to do it, but you have some responsible states that may institute some good policy and say, well, we're going to create this, and there's not going to be any, once we kind of tenure these people, there's not going to be any repercussions to them, to say that someone can have their tier reduced or taken off the registries altogether. I think that's where it would go once the U.S. Supreme Court got hold of it. Enough of the courts of appeal. Unfortunately, I'm under the Fifth Circuit, which is one of the really conservative ones. It's just Mississippi, Louisiana, and Texas. The Fifth used to include Georgia, Alabama, and Florida, but they carved the 11th off of it, quite some time ago. So and the only thing that's come up through the Third Circuit is Duarte versus City of Louisville in Texas, in which was about residence restrictions, and we kind of got it poured out. They got poured out so bad on the victory they had below that it actually scared the executive director of the ACLU of Louisiana off. She had went from being gung-ho and saying that we're going to challenge this in the federal courts in the Middle District of Louisiana, to saying, maybe it's better if a bigger organization that's better funded and so on in Texas do this. We don't want to make any bad law in the Fifth Circuit and blah, blah. And the next thing I knew, she resigned. So I hate to be saying, not giving you very much that's encouraging there, but that's kind of where it is. I think we have to litigate it. We have to do it, but we don't want people bringing pro se litigation. We don't want lawyers who don't have the help that they need doing it. And we want to make very, very good records. And then maybe we have a chance if we draw the right panel from the Fifth Circuit.
So thank you for your time and for your efforts. I appreciate it.
Okay. Well, thank you for participating.
Thank you. So I think this is going to be the last call here. Area code 276. Go ahead.
Hi, this is Tammy from Virginia.
I remember you, Tammy.
Well, thank you. I just had one question about what I had called in earlier about. I got the impression that I could either try to file for clemency through an attorney or hire a civil rights attorney to pursue what I'm trying to do. In your opinion, which one do you think would be best for me, and why?
Well, even though I don't practice in Virginia, and let me say, I was listening when you told your story, and I'm very sympathetic with you. I was shocked, as I think Larry was, at hearing that they required you to be on the registry, because they said, oh, you as a parent, had an obligation to report this situation sooner. You didn't do it. I have a client who has to register because they said that his 16-year-old daughter was carrying on with a man who is of age, and 16 is below the age of consent in Louisiana, in his home, and that he either knew it or he should have known it. And so he pled guilty to 2 counts of principal to carnal knowledge of a juvenile. And with the victim being his daughter, someone hears, what, he's convicted of carnal knowledge of a juvenile, and the victim is dead, makes it sound like he had sex with a daughter. He didn't, you know. They're just saying that he knew about it or should have known it. He was originally charged with a whole lot of horrible stuff because it was a very crooked detective whose crookedness came out to the point that the district attorney were having to disclose that she had withheld Brady material. So long story. But it's pretty easy to answer your question when you say, should I get clemency? Clemency to me is when you are incarcerated and you're trying to get your sentence cut down. You know,
I was using that loosely in terms of a pardon.
Yeah, well, a pardon means you're no longer convicted at all, and these are both through usually the governor's office.
Right, and I was using that term loosely.
Oh, okay. I thought it was she who used the term.
No,
but maybe that's
I'm
where
the
she
one who
got
brought it up. But I thought that using the loose term that there is a possibility. The governor of Virginia right now is not a right-wing fanatic, so there is a possibility.
Yeah.
There is a possibility that a compelling case properly brought through that process that the executive branch has might be of interest, but it's a long shot. But if she runs out and files a lawsuit saying the statute is no good, most pardon attorneys are not going to be particularly sympathetic at the same time, because I've worked with executives. I know that they want you to be very remorseful, on your knees crying, and they don't want to. If you're challenging something, then you haven't learned your lesson yet, is their general attitude.
You know, when you're asking for a pardon or a commutation or a clemency, you're coming with your hat in your hand. And if at the same time, give me this, or I'm going to file a civil suit and try to get your law struck down, and you send your legislature scrambling back to the table to pick up the pieces, that doesn't necessarily put you in their good graces. Now, we have a governor in Louisiana who's a Democrat and who's very interested in criminal justice reform, but and he's had, even from the very beginning, most governors wait until they're on their way out of office is when they do pardons and commutations. Not this guy, John Bell Edwards. He has had a very active clemency and commutations office from the very beginning, and he'll probably only get one term. Just from the political realities here. But I'm not hearing that they're receptive to that in the case of people convicted of sex offenses. The person who killed somebody gets a better break, and even under our regular statutory law, a manslaughter gets 15% off for diminution of sentence, so what they call good time parole, but the parole board's not involved. Nobody who has any kind of sex offense gets any of that. Their time is always flat. So it makes no sense. It's upside down. Now, about a civil suit, you say, well, hire a civil rights attorney. If you're going to hire them outright and pay them to do it, you're talking about a whole lot of money. The best most people could hope for is to be able to bring a little bit of money to the table and have a case that lawyer thinks is good enough that their chance of prevailing and winning a statutory attorney fee award is good enough for them to spend the time on it. And it's hard for me to tell you. I mean, I'm licensed in I passed 3 bar exams: Louisiana, California, and Texas. I don't keep up California or Texas anymore. It's just a matter of paying money and transferring continuing legal education transcripts. But I only really practice in Louisiana now, and the U.S. Supreme Court and the U.S. Fifth Circuit, which is in Louisiana. So it's hard for me to tell you what you should do. Clemency, what is available? I guess the question is, in Virginia, what is available to you in terms of getting off the registry or improving your classification on the registry? I frankly have no idea.
Well, she said that there's nothing, that it's a lifetime obligation.
So well then the only thing that could get you off it would be what we call a gold seal pardon, which is a governor's pardon. There in Louisiana, there is what they call a first offender's pardon that you get automatically after so many years. But I don't think that takes a person off a registry. In fact, it may even be. It seems like sex offenses are the exception to everything good that a convicted person convicted of any felony can experience. And I've having been in the legislature this week and last week, and particularly yesterday, a speech I heard in the Committee on the House Administration of Criminal Justice of the vice chair of the thing, carrying on about sex offenders and stuff, and things that he's seen, didn't give me a whole lot of hope for reform coming very fast from that. I really think it only comes from Article 3 judges who are life tenured in federal court telling Louisiana, you cannot do this. It is not rational. Here are some parameters of what you can do. Now go back and start over.
Well, she has a real dilemma, because if she goes, don't know what kind of financial resources she has, but if she has financial resources and goes and talks to an attorney about any action on behalf of the executive, they tend to do a little bit better if you have a person who's done that before. They know the pardon attorney. They know how the governor thinks. Right. The pardon attorney has a good relationship with the attorney, and they'll be honest enough to tell them, well, my governor's not going to do it because they're running for re-election. My governor will consider it because my governor doesn't give a damn about re-election, in the case of what John Bell Edwards may be. So she's got to hope that she finds an honest attorney that actually knows how the pardon process works in Virginia, that there are attorneys out there. I know that it's unbelievable to most, but there are attorneys out there who will tell you that they know how to do something to get your money, and they'll tell you that I've got experience with this, and they haven't. And they'll tell you that for $2,500, I'll do all the paperwork to get you a pardon. Well, I can take you $2,500, but that doesn't mean that I know the process. Doesn't mean that I know what the governor is looking for, and which is really the pardon attorney that works for the governor. You don't know what the pardon attorney is looking for in terms of whether or not you're going to get it. The pardon attorney is going to decide your case, unless you're a high-profile person that has done something that would immediately get on the news. The governor is just going to sign off on it if it goes through all the criteria and the pardon attorney recommends it. The governor is going to sign off on the pardon in all likelihood. But if you had something where it brought a lot of notoriety to you, the standards of the office is going to be, I want those to be brought to me, and I want to know that this is going to bite me in the ass publicly.
Yeah.
So you've got to hope that you find an honest person that'll give you the scoop on what your chances are with a pardon. Well, I'm one of those people that'll tell people the honest truth, and that gets me in a lot of trouble, because I tell them, look, as best I can tell you, our governor is a former prosecutor. To my knowledge, in her 8 years, she has not granted any clemency of any type. I do not believe there's anything you could do to get clemency for this person. Now, if you want me to take your money and help you, I can do that, but I don't believe you're going to get it. Well, they don't like that answer, and they'll go down the street and they'll talk to another attorney who tells them, I played golf with it, and I do all this, and I believe I can get you a pardon. Which message would you rather hear?
Yeah, and I can tell you, in Louisiana, we're fortunate because, and it wasn't always so, but there was one really leading pardon and paroles attorney who now limits his entire practice to doing only that. His name is Keith Nordyke, and when I tried that, or before I tried that computer-aided solicitation case, Client A, that we were talking about tonight, and I wrote this memorandum that raised all the constitutional issues and broke all the problems down and composed the 8 hypotheticals, which demonstrated how totally absurd the statute was in its original form. This man wrote me a fan letter out of the blue, and I was nobody. He is actually the founder of the Louisiana Parole Project, and he's a totally good-hearted and honest man who would tell any person what he thought their chances were, and whether he couldn't in good conscience take their money, or whether they had a chance, and here's what you do. And he has kind of reputation that a good person like that, dedicated person like that, should have with the whole process. They know who he is. They know that if he took the case, then it's not a BS case. You would have some homework to do to find out who is the go-to person for pardons and paroles. Now, back in the Edwin Edwards era, it wasn't who is competent and honest, it's who is personally connected to Governor Edwin Edwards, who can pass a lot of cash that you provide the attorney to the governor or his cronies through some back channel. And he did a whole lot of pardons in the end, and it was all going through his brother and people. You know, that's the kind of stuff Louisiana is notorious for. But that's not what we have going on right now with our governor and with this other pardon attorney. I have no idea who it would be in Virginia, but if you start asking around with the state criminal bar for some referrals, and you don't want to just, you know, go to anybody for that, because like Larry's saying, we see this with post-conviction relief. Someone who charges $10,000 to look over the record or post-conviction release, and then they study the record and they say, well, okay, I don't see anything. You know, you don't want that situation. And there are people who will take advantage, but you want to get the referral to that person who won't take advantage of you and who will be honest with you about your chances of doing yourself any good. You don't want to just throw money at this and lose it.
No, and be receptive.
Okay, I'm glad I could help.
To what they tell you. When you start knocking on doors, you can knock on doors to hear what you want to hear, or you can knock at the door of a well-respected person who may tell you what you don't want to hear, but it may be the reality of the situation. So have your mind open that what you're wanting to do, that may be of a very, very slim chance. The same thing with the civil action. I don't think that your case would be as costly if you were to bring a constitutional challenge as applied, meaning that it's unconstitutional as applied to you, because you wouldn't need a lot of experts, I wouldn't think.
It's a single issue.
Yeah, it's a single issue. So you would probably have a better chance if you went in on an as applied challenge. It would not be tens of thousands, but it would be thousands of dollars, because the state fights back. They don't just fold their tent. Oh well, yes, this is unconstitutional.
Yeah.
So the state is going to fight back.
I know Virginia's commonly correct, because the same prosecuting attorney that offered me this plea is now a judge who turned around and gave me custody of all three of my grandchildren.
So, that's the best interest of the child standard. It's a different thing.
That I'm on I know she knows I'm on a damn registry. I mean, and the kids are safe with me. She knows that.
Man.
Okay. I'm going to take your advice to heart, because I am in a financial position where I could get money to hire someone or do something in my defense. But I'll be very careful and wise and open-minded toward that.
That's
and I
right.
do appreciate it.
Yeah, you want to find out someone that you know you can trust, who has got a good reputation in the legal community, and find out, you know, who is the go-to person for this. And you don't want to dress up your facts and put them in the best light. You got to disclose everything and let that person make a good objective decision. But I agree with Larry that you would have, I think, a pretty good as applied thing, and it depends on how egregious, how long did you know, what did you know, and what are the legal standards there that make that criminal in your state. If it's dubious, and I assume you took a deal rather than going to trial.
I did. I took a plea.
Yeah.
I took a plea. I knew my son was having sex with this female for about 2 months. I tried to stop it on my own because he was living with my sister, and we didn't want the law involved. We just wanted to get it stopped. And finally, when he kept running away, breaking his ankle bracelet, tore the rivets off, and left it at home and stayed gone for 3 days, I had no choice but to go to the sheriff and tell him, hey, my son took off. He's with this female. Do you know this female? Yes, I know her. Well, where does she live? And I told them. And they found my son there at her house, naked at her house. They charged her with carnal knowledge, shipped him off to juvenile. Everything was fine. About 2 or 3 months later, they come back and charge me with indecent liberty of a child with supervision or custodial arrangement. Number one, I didn't supervise him because I didn't have custody. Number two, I didn't allow him to do it, but I did fail to properly inform him when I first found out about it. So that's what I'm guilty.
Well, let me make a wild guess here, and I don't mean to be offensive, but I bet when you talked to the detective, you told him, "Yeah, I knowed about it. Yep, yeah," because they told you they were from the government and they were there to help, and
Yep.
you believed if you just put it all on the table that they're so busy and overworked they would never prosecute you. Yeah. Huh?
You know
I wish I had never told them nothing.
Yes,
Yeah, but see,
we have in Louisiana the Department of Children and Family Services is who gets called for, and DCFS lawyers say that stands for Don't Call the Effing State. Because most often people are sorry they ever got them involved, because they want to get in on set of kids playing doctors with each other and get in there and put a white hat on one, make it a victim, and the black hat on the other one, and make that one a perpetrator, make a big old case out of it. And people are very sorry. They thought that the police are here to help you, and they're fault. Well, the thing to do, we're always taught the thing to do is to call the police when these things happen. No, they just want to make cases. They want to take people down, and the grinding wheels of the system take all the machinery of the state comes down on you. People used to handle this kind of stuff differently, and I think they had a better idea than we do today. We've got a really sick system today.
Yeah, it's horrible. But anyway, thank you all. I will seek out the solutions that I feel are necessary for me to go forward, and I do appreciate it.
Look, this fella Keith Nordyke in Baton Rouge probably knows who is the best person who does what he does in Virginia. So that's an idea. If you would contact his office in Baton Rouge and ask for a referral of someone in Virginia, and that would be a good idea, I think.
Let me get a pen right quick. And what's his name now? Keith what? Baton?
Nordyke. And he's online. He's in Baton Rouge, and he really is ace. He really cares. He's involved in he's involved in all kinds of works, and so that would be your best chance of finding exactly who you need in your state.
Thank you. I will certainly look into that this very week.
Great.
So, well, King, I think we're going to wrap up.
Good deal. I've enjoyed it.
We're going to see you up in Independence, Ohio in June?
I hope so. I have been trying to keep my schedule clear. One court conflict has popped up, and I'll have to look and see what it is and see if I can't clear it. And Independence, Ohio is close enough, really. If I rented a car, I could go visit my sister and brother-in-law in Warren, Michigan, up in the Detroit area, up around the lake. If I could get away for that long. The one in Atlanta, I was able to see my son. So that's try to kill two birds with one stone when I make these trips.
So we'll be delighted to see you again, and we'll be having you back. And we're always glad. And I'll probably get you and I and the attorney that I talked to together about her ideas and see what we can come up with on some litigation. And see if we can explore that, because I was very interested in that. And that debtor's prison that they're running in Louisiana.
And there has been some federal court success against some of the aspects of Louisiana desert prison stuff. So I'm very interested in helping with that if I can.
So, well, everyone, thank you for joining us. The few that are left, it's now tapered down to a handful. So thank everyone. We'll be in touch with you about the next call. Don't know when it'll be, but thank you for joining us. I'm going to turn off the recording now.